and the worldwide feminization of poverty and labor migration. Louder? Okay, louder. The integration of gender perspective is therefore essential to the analysis of the position of female migrants and development of policies to counter discrimination, exploitation, and abuse. Taking into account the root causes will clarify the point, and I want to make reference to the general comment number 38 that was adopted by the CEDAW committee. The committee observed a gender analysis of trafficking reveals that its root causes lie in sex-based discrimination, including the failure to address the prevailing economic and patriarchal structures and the adverse and gender-differentiated impact on the labor, migration, and asylum regimes of state parties. They create a situation of vulnerability, including to women and girls being trafficked. Globally dominant economic policies further exacerbate large-scale economic inequality between states and between individuals, which manifests as labor exploitation. Globalized macroeconomic and political factors, including the privatization of public goods, the regulated labor markets, the striking of the welfare state, and austerity measures, forming part of structural adjustment policies, and as a had conditionality, often exacerbate unemployment and poverty and produce economic injustices that have a disproportionate impact on women, often accompanied by other economic such as reduction in government spending on social services and the privatization of public goods and services, regressive tax shifts, and labor market reforms all severely hamper states' abilities to implement social policies that form the basis for dismantling structural inequalities, including gender inequalities and violations of women's rights. That said, I would just to focus on two reasons which are of interest as I see things. The first is the challenge, which is embedded in migration flows and this rising number of women taking part in the migration flows. The challenge which migration flows gives rise as regards the protection of human rights. And the second point of interest is, as I see things, intersectionality. I want to highlight some of the weaknesses marked by international legal norms protecting women's rights. The feminization of poverty has given rise to new forms of female exploitation and the widening of trafficking of female migrants. The UN Protocol on Trafficking does not aim at protecting and promoting human rights, since it has been conceived as an instrument of control on migration. The preamble makes reference to the protection of the victims of trafficking, emphasizing a post facto viewpoint, and limits the protection of human rights to the part of the process when individuals have been trafficked. The protocol has dilated the role of positive human rights obligations in the prevention of trafficking and the protection dimension of victims. The rules the protocols lie down foster return to the country of origin rather than guaranteeing stay in the receiving country. Readmission obligations incumbent on countries of origin are formulated in a mandatory way, and a detailed regulation is provided for. But there are not detailed provisions imposing hard human rights obligations on the receiving country to protect trafficked persons. But a generally formulated clause is laid down in Section 4 of the protocol. Violence embedded in both of them is part and parcel of a broader trend involving women in different stages and fields of their life. In this perspective, the economic and social rights international treaties endow migrant women with are a litmus paper of the capacity of the international protection of human rights to dismantle the connection between poverty and violence upon which male domination is based. In General Recommendation 26, the CEDAW committee argued that whatever the situation women migrant workers face, additional hazards compared to men because of gender-intensive environments that do not allow mobility for women, and that give them little access to relevant information about their rights and entitlements. Gendered notions of appropriate work for women result in job opportunities that reflect familiar and service function ascribed to women, or that are in the informal sector. Under such circumstances, occupations in which women dominate are in particular domestic work or certain forms of entertainment. This brief consideration of the status of women migrant workers in countries of destination calls into question the role of economic and social rights. The weakness of women migrant workers within the labor market enhances the social division of labor, namely the clustering of women in specific labor fields and positions, and clarifies that the traditional approach that the ILO and the Council of Europe Convention have adopted towards social and economic rights, an approach which is grounded on the mere application of the principle of non-discrimination, and that cannot remove those obstacles to the enjoyment of rights in the field of employment, occupation, and social protection, stemming from the discrimination on the grounds of sex and gender that women migrant workers suffer. The CEDAW has improved the protection of women and women migrant workers since it puts an end to the distinction between the public and the private sphere. Discrimination against women falls within the scope when committed by any person, organization, or enterprise. Article 2 and Article 3 establish the duty of taking appropriate measures in the economic and social fields to ensure the full development and advancement of women. In this vein, Article 11 tackles structural factors of inequality between women and men in employment and occupation. This provision is based on a recognition of the complex realities of women's economic, family, and employment situation, and provides for a series of states' obligations to eliminate discrimination. The aims of the rules enacted by Article 11 are to ensure substantial equality through the removal of direct and indirect discrimination affecting women and preventing them from acceding to occupation. Moreover, the system of eradication of discrimination against women set out by Article 11 is strengthened by the provision contained in Article 13 of the Convention. This imposes on state parties the duty to take all appropriate measures to eliminate discrimination against women in all the areas of economic and social life. The rule covers the right to self-employed economic activities, food, adequate housing, adequate standard of living, water, and sanitation. Notwithstanding the improvement of the protection of women's economic and social rights, the CEDAW has achieved the root causes of gender discrimination the root causes of gender discrimination were not erased. I think I need glasses. Economic and social rights were not conceived for preventing violence against women. Furthermore, the crisis of the conception of labor rights as human rights has undermined the effectiveness of the rights international conventions lie down. Moreover, liberalization has pushed several public-funded social services to the realm of private business, affecting the poorest part of society. The shrinking social protection stems also from the policies of loans pursued by the IMF and the World Bank, obliging the recipient states to cut down welfare protection. The spreading of poverty does not affect women's rights, but exacerbate the discrimination, contributing to increasing violence against women. The reference to violence and gender discrimination is crucial in understanding and assessing the law on refugees. The CEDAW committee stated that gender-related forms of persecution are forms of persecution that are direct against a woman because she is a woman, or that affect women disproportionately. The committee observes that understanding the way in which women's rights are violated is critical to the identification of those forms of persecution. The committee knows that violence against women, that is a prohibited form of discrimination against women, is one of the major forms of persecution experienced by women in the context of refugee status and asylum. Such violence, just as other gender-related forms of persecution, may breach specific provisions of the Convention. Such forms are recognized as legitimate grounds for international protection in law and in practice. 1951 Convention does not envisage gender-related persecution. However, pursuant to the CEDAW Convention, state parties are required to take proactive measures to ensure that the legally recognized grounds of persecution, including those enumerated in the 1951 Convention relating to the status of refugees, such as race, religion, nationality, and so on, are given a gender-sensitive interpretation. In addition, gender may be used as a factor in recognizing membership of a particular social group, or indeed as an identifying characteristic of such a group for purposes of granting refugee status. Such an assessment should halt an interpretation of the 1951 Convention grounded on stereotypes. The committee, the CEDAW committee, warned that a social group grounded definition of a refugee, which might reinforce the stereotype and notion of women as dependent victims. Article 5 of the Convention requires state parties to assess women's claims to asylum without prejudices and stereotype notions of women that are based on the inferiority or superiority of either sex. The last point of interest, which is entrenched in migration flows, is intersectionality. This legal item has gained purchase over the years. Making intersectionality viable in discrimination law involves two inquiries. The first of these inquiries is, how has intersectionality been conceived in discrimination law? The second inquiry is, how should intersectionality be conceived in a way that truly represents its core principles? Both inquiries entail a further issue. Are courts and tribunals ready to apply this concept in assessing intersectionality? The case law of the Court of Justice makes it clear how complex the problem is. The EU law is fragmented, but despite that, is grounded on principle that could enable judges to take into consideration intersectionality when facing with women affecting intersectional discrimination. However, despite that, the Court of Justice was not ready to use intersectionality as a key concept in assessing EU law. In the ruling the court delivered in Paris versus Trinity College Dublin, the Luxembourg judge stated that while discrimination may indeed be based on several of the grounds set out in Article 1 of Directive 2078, there is, however, no new category of discrimination resulting from the combination of more than one of those grounds, such as sexual orientation and age, that may be found to exist where discrimination on the basis of these grounds taken in isolation has not been established. We refugees, Hannah Arendt wrote, we don't want to be refugees because we don't want to be Jews. The idea line behind this statement, this properly statement, was that refugees, and more general sense migrants, have to lose their identity in order to be accepted by society in which they live. So hosting countries are hostile. Hosting countries are hostile countries, indeed. That was the idea. I try to explain that the protection of human rights, international system of force, has to guarantee women, not all, because they are vulnerable. So the idea is to go beyond their vulnerability and to ensure the protection of their fundamental rights. In so do I think that the challenge is to ensure their identity. So to let them be as they are, which does not entail only to keep the cultural, religious traditions, but it entails to maintain their diversity, which is to be a woman. I think time is ripe for giving the floor to our speakers. I want to thank them because they accept to contribute to our analysis of gender and law. And so I want to give the floor to Professor Francesca Mussi, Professor of International Law in the University of Trento, and she's to go with migration flows and the protection of women's rights. Professor Mussi, the floor is yours.
Thank you, Chair. So first of all, I would like to thank the organizer very much for giving me the opportunity to be here, and a special thank goes to Professor Evola and Professor Puma for giving me the opportunity to share my views on such an interesting topic. So my presentation concerning is titled Migration Flows and the Protection of Women's Rights, and aims at examining, let's say, international migration through a gender lens, with a special focus on relevant gender-based human rights concerns relating to migrant women and girls. To do so, I hope to be able to do so at least, I will structure my presentation into 3 different parts. So in the first part, I will try to identify what are the gender drivers of migration for women and girls. Then, moving to a more legal dimension of the phenomenon, I will try to analyze the international legal framework governing gender and international migration with a particular regard to the applicable international human rights law instruments. And finally, in the third part of my presentation, I will highlight some let's say, specific human rights challenges that migrant women and girls face at different stages of the migration process. So let's start with the gender drivers of migration for women and girls. Some of them have already been highlighted by Professor Evola, so I will try to cover the remaining. So as we already said, men and women migrate for similar reasons, such as the desire to receive a better education, to find work, to improve the quality of life for themselves and their families, and to reunite family members. Migration can also be caused by duress, such as the need to flee conflict and persecution or economic precariousness. And in addition, let's say, particular drive of migration are a lack of opportunities for young people for food insecurity, environmental degradation, and natural disaster. On the other side, at the same time, it has become increasingly clear that migration is a gendered phenomenon. So gender-specific norms governing society are fundamental factors, as are gender expectation, let's say, and differentiated power relation. The differentiated impact of economic inequality shapes, let's say, the reason for which women and girls migrate. Those reasons vary considerably compared to the reason for which men and boys choose to migrate. And it is equally important to note that migrant women and girls are highly heterogeneous group with different profiles and socio-economic characteristics. An important factor, okay, causing the migration of women and girls is gender expectation, we have already said, as families generally may send abroad their daughters rather than their boys, because they believe that their daughters are more likely to send home remittances, for instance, and before any person migrates, negotiation at the household level usually takes place. During such negotiation, rather than seeking to completely upend the gender hierarchy within their families, women and girls instead co-opt prevailing gender discourses in order to win over powerful stakeholders. Women therefore frame their migration aspiration in gender terms, presenting themselves, and once again, we've already seen it, for instance, as dutiful daughters and caring mothers, and promising to remit most of their overseas earnings to ensure the future well-being of their family members left at home. And Playing on gender expectation and norms is not limited to aspiring migrant women, but can also include men who are able to call upon well-established gendered images of the male breadwinner or of authority when wanting to migrate and use them to fend off resistance. The prevalence, let's say, of sexual and gender-based discrimination, harmful practices such as child, early and forced marriage, violence, and unequal access to rights and resources are crucial reasons why women and girls migrate. And as such, women's desire to migrate may be motivated by a desire also to escape family control or a deep-seated discrimination that restrict their access to resources, education, and political participation. If these are the most relevant, let's say, gender drivers of migration for women and girls, which is the international legal framework governing the relationship between gender and international migration. So to answer this question, we must start from a basic starting point. There is no universally accepted definition of an international migrant, even though, as we said, some group of non-national fall under the protection of a specific international legal framework. And we have talked about refugees, and we have talked about the trafficked person and migrant workers. Therefore, in general terms, the legal and normative framework to protect international migrants cannot be found in a single treaty or mechanism, but is much more, let's say, diffused through a rich set of instruments and related principle and standard. Apart from that, all international migrants are protected under international human rights law. And for those who are familiar with international law, human rights are rights inherent to all human beings, regardless of race, nationality, ethnicity, language, religion, or any other status, and they are universal, indivisible, interdependent, and of equal importance. And in addition, for the purpose of our analysis and for our discussion, international and human rights law require that every person enjoy his or her rights without discrimination. Discrimination included on the basis of sex. Discrimination based on sex is prohibited under the International Covenant on Civil and Political Rights, first of all, and the International Covenant on Economic, Social, and Cultural Rights for the enjoyment of all the other rights which are set out in these instruments. In addition, under the Convention on the Elimination of All Forms of Discrimination Against Women, which is the most relevant legal reference when we talk about the relationship and the protection of women also with regard to migratory phenomenon, discrimination against women is prohibited and states are obliged to eliminate discrimination against women. There are 189 state parties to this convention. Which include the obligation, first of all, to suppress trafficking in women, and the reference is to Article 6. In addition, the CEDAW Convention grant women equal rights with men to acquire, change, or retain nationality, Article 9. Eliminate discrimination against women in the field of employment, Article 11. Eliminate discrimination against women in the field of healthcare and ensure access to healthcare services, including those related to family planning and maternal care, Article 12, and accord to men and women the same rights with regard to the law relating to the movement of persons and the freedom to choose their residence and domicile, Article 15, paragraph 4, which is particularly relevant for us. And some, let's say, additional indication have been provided by the Committee on the Elimination of Discrimination Against Women, which is the body of independent expert which monitors the implementation of the CEDAW Convention, which in its general recommendation number 26, which dates back to 2008, address a specific issue which is relevant for us because it has to do with the women migrant workers who travel independently, or those who migrate as dependents of their spouses, and those in irregular situation. And in its general recommendation number 26, the Committee on the Elimination of Discrimination Against Women outlined a set of responsibilities that should be assumed by states, okay, including implementing gender-responsive and rights-based migration policies involving women in policy making, safeguarding remittances sent by women migrant workers, collecting data disaggregated by gender, and lifting discriminatory bans on women's freedom of movement. Also, the last, let's say, relevant international instrument is represented by the International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families, which provide for the rights of migrant workers and their families without discrimination, once again, based on sex. If this is the international legal framework governing gender and international migration, we must also bear in mind that there are also intergovernmental initiatives which are not strictly binding, let's say, but which at the same time provide a useful indication in this regard. And I'm thinking about to the 2030 Agenda for Sustainable Development and the New York Declaration for Refugees and Migrants and the Global Compact for Safe, Orderly and Regular Migration. The 2030 Agenda for Sustainable Development, first of all, is grounded in international human rights law. And its 17 Sustainable Development Goals have the aim of realizing human rights of all persons, while goal number 5 has a specific emphasis on gender equality and empowerment of all women and girls. And achieving goal number 5, that is achieving gender equality, will make a crucial contribution to progress across all the goals and their targets, including a goal number 8 to promote economic growth and decent work for all, and goal 10 to reduce inequality within and among countries, and particularly target 10.7 to facilitate orderly, safe, regular and responsible migration and mobility of people. If we have a look at the New York Declaration for Refugees and Migrants and the Global Compact for Safe, Orderly and Regular Migration, which were adopted by the UN General Assembly in 2018, in paragraph 23 and 31 of the New York Declaration for Refugees and Migrants, the UN General Assembly recognized the specific vulnerability of women on the move. And the UN General Assembly expressed in that occasion its commitment to ensure that the responses mainstream a gender perspective, promote gender equality and the empowerment of all women and girls, and respect and protect their rights. And it is also recognized at paragraph 31 the significant contribution and leadership of women in refugee and migrant communities, and committed to ensure women's full and meaningful participation in the development of local solutions. Set in motion by the adoption of the New York Declaration, as I told you before, a process of intergovernmental consultation and negotiation on migration concluded with the adoption of the Global Compact for Migration. Gender responsiveness is established in the compact, in the Global Compact, as one of its guiding principles. And states are called upon to ensure that the human rights of women, girls, and especially girls, are respected at all stages of migration. the same must be done with regard to their specific needs, which must be properly understood and addressed. And migrant women and girls are empowered as agents of change. So this is what the Global Compact on Migration said. And under the Compact, a gender perspective is mainstream, and gender equality and empowerment of all women and girls is promoted with the recognition, I quote, of their independence, agency, and leadership in order to move away from addressing migrant women primarily through a lens of victimhood, because this is the traditional point of view according to which women has been framed as a subject of migration. Also, if you have a look, for instance, at the definition of smuggling and trafficking, you can find in the UN additional protocol to the Convention Against Transnational Organized Crime, especially in the trafficking protocol, I have this feeling that the victim, women are framed and are conceived, especially as victim of this phenomenon. So in the Global Compact, I think maybe for the first time, we have this strong feeling that at the UN level, something has changed, and the idea is to see migrant women not exactly as victim of the phenomenon, okay, but also as a fundamental point, as a fundamental element in order to change this approach, in order to, let's say, highlight their potential role as leader, okay? In addition to these intergovernmental processes, there are also several regional, trans-regional, and international fora with the aim of addressing specific issues related to gender and migration. Just to mention a few, the Colombo process, the Abu Dhabi dialogue, the Addis Ababa action agenda of the Third International Conference on Financing for Development, the Ibero-America Forum on Migration and Development, and the Global Forum on Migration and Development. The last section, the last point I would like to address in my presentation concern some specific human rights challenges that women and girls face at different stages of the migration process. While doing some research, I identified quite many of them, but today I'm going just to highlight what I think are the most important one. And I think that among the different human rights challenges that women and girls face in face during the migration process are those connected to access to health care, including sexual and reproductive health and education. Migrant women and girls often do not have reliable access to healthcare or reproductive healthcare services, especially in transit and destination countries. Their lack of access is due to factors such as the lack of information on health-related education, isolation, or the inability to gain access to services based on legal status, for fear of deportation or other repercussions, particularly for migrant women and girls who find themselves in an irregular situation. This is quite clear. And as it has been highlighted by the Special Rapporteur on the Human Rights of Migrants in 2018, states should ensure that there is a strict separation, let's say a kind of firewall protection between public services and immigration authorities, allowing migrants to exercise and enjoy their rights without the fear of being reported to the immigration authorities. And once again, is the kind of relationship between public and private you highlight during your presentation. In addition, the Committee on Economic, Social and Cultural Rights, in its general comment number 22, which dates back to 2016, on the right to sexual and reproductive health, declared that the right to sexual and reproductive health represent an integral, fundamental part of the right to health, which is set out in Article 12 of the International Covenant on Economic, Social and Cultural Rights. And the committee recognized that the right to sexual and reproductive health is indivisible from and interdependent with other human rights, while it is also affected by the social inequalities in society and unequal distribution of power based, once again, on gender, ethnic origin, age, disability, and other factors. And the committee, in the general comment number 22, emphasized that migrants may be disproportionately affected by intersectional discrimination. Once again, intersectionality come back also in my presentation. And as a consequence, states are obliged to take particular steps to ensure that migrants have access to sexual and reproductive health information, goods and services, and to ensure that individuals are not subjected to harassment for exercising their rights. Another important aspect, at least to me, of the protection of the human rights of migrant women and girls is to ensure their access to justice, which is particularly challenging for migrant women and girls which find themselves in an irregular situation. As the Special Rapporteur on Migrants' Rights outlined in his report on access to justice for migrants adopted in 2018, firewalls, or the strict and real separation between the immigration authorities on the one side and public services on the other, are fundamental for migrant women to exercise and enjoy their human rights without fear of being reported to the immigration authorities. This link between public services and the fear that migrant women have to be reported to public services, to immigration authority, came back in different, from time to time and in different occasions. And it is this firewall that allow migrant women and girls who may become a victim of any form of violence or abuse to report the crime, to obtain legal assistance and gain access to the court to defend their rights. Then there are also some specific challenges. I think that this is an aspect which has not been analyzed in detail so far, and of course which deserve to be discovered. So I have just some preliminary remarks I want to share with you, but I'm sure there will be other occasion to analyze this aspect. I was saying that there are some specific challenges which are faced by particular categories of migrant women and girls, such as those belonging to lesbian, bisexual, transgender, and intersex community. And some aspects are also connected to the possibility of recognizing them as refugees according to the broad category of membership of a particular social group included in Article 1 of the Refugee Convention. And within international human rights law, there is a well-established framework to promote the respect for sexual orientation and gender identity. And UN human rights treaty bodies have recognized that sexual orientation and gender identity, including gender expression, are prohibited grounds for discrimination. as it is with regard to race, sex, or religion. And the UN human rights mechanism have also expressed concern with regard to human rights violation based on gender identity, including gender expression, and have called upon the state to address such violation. In particular, the United Nations High Commissioner for Human Rights has exposed at length the many violations that lesbian, bisexual, transgender, and intersex persons face around the globe. And these, let's say, women belonging to these categories have also an increased risk of becoming victims of tortures and in treatment, including in clinics and hospitals. And some countries still criminalize consensual same-sex relationship, and in at least 7 countries, the death penalty may be applied. Research has demonstrated that migrants who are members of the lesbian, bisexual, transgender, and intersex community often experience discrimination and stigmatization from both their, let's say, communities of origins and also in the country of destination and along the migratory route. So those negative experiences may be compounded for transgender person as well. And for example, while in detention for irregular entry and stay, transgender women can be exposed to social isolation and be subjected to physical and sexual violence. This approach is in part a reflection of the narrow scope of defining sexual violence and the limiting binary, let's say, vision of women victims and men perpetrators, as we said before, which ignore the complex reality of sexual violence. So my time has run out, so that's all from my side. I thank you very much for the attention, and I'm ready to answer any question. Thank you.
I want to thank our distinguished speaker for her assessment of the international framework protecting human rights. Very sorry for remind you that there's time limit. Just to highlight the main points of your assessment, the first is the shift from the principle of non-discrimination to the positive obligation being imposed on state in order to promote the protection of women's rights. The second is the change of parameters that is gaining ground mainly when international organizations work through soft law, but it's quite important to remind that there's not only rules established by treaties, but also soft law and the role it could play in advancing rights, and then the role that the protection rights could have if it's supported by judicial and non-judicial instruments of redress. And the last point, you widen the focus, recalling also the protection of LGBTQ communities and the rights and the need for not considering only sex discrimination, but also gender discrimination. So thank you very much. Now, I want to thank the second distinguished speaker, Dr. LAWGEME, who is not here. I want to thank her because despite international engagements, she accepted to support our studies and contributing. Dr. LAWGEME is public prosecutor in the Public Prosecutor Office of the Tribunale Palermo, and she's going to assess trafficking and sexual exploitation of migrant workers. Dr. LAWGEME, the floor is yours.
Thank you very much for inviting me and for accepting my intervention at a distance. I'm currently at Eurojust, where I can address the issue of migration and the gender issues from a different viewpoint, which is the one of an international organization, which is an international agency, which is committed, among the others, with the issue of protection of women and vulnerable victims with regard to human trafficking and smuggling of migrants. My experience comes mainly from the activity which I've carried out as a criminal prosecutor, as correctly said, in the Palermo prosecution office, where I've been and I'm currently in charge of many cases of smuggling of migrants and human trafficking. And sadly and regrettably, I need to say that since the very beginning of my experience in the specialized group on human trafficking, I've had the chance to realize that.
I'm sorry, could you speak louder and louder, please?
Yes.
Or maybe you can approach the microphone.
Can you hear me better now?
Now it's better. Now it was.
Okay, thank you.
It was well. Thank you.
Thank you. As I said, one of the first evidence that I gather as long as I started my experience as a criminal prosecutor in the Palermo prosecution office was that the percentage of women involved in the human trafficking was much higher than that of men. This is the first evidence, the first fact that we have to address, and which is definitely confirmed by the data, the official data that we are given from the international organization, because the 95% of the registered victims of human trafficking are sadly women, and this is ascertained not only in Italy but in the whole Europe. And I need to highlight that we are speaking only of the registered victims, and we know sadly that we are facing a phenomenon in which the number of unregistered victims is much higher. So we need to admit that the gender issue is dramatically impacted by the phenomenon on human trafficking, which is addressing especially women who arrive to our countries in difficult and vulnerable condition, because we are speaking about women that in their country of origins often don't have the access to the health services, don't have access to the cure. They often arrive to our country in condition of pregnancies or with children that they do have to care of. So we are speaking about women who are particularly vulnerable victims, and the issue of vulnerability is very important to be addressed by the criminal prosecutor, and this is a battle that the Palermo prosecution office has faced and supported so long, because it's important to highlight that in our criminal code there is not a clear definition of vulnerable victim. The definition of vulnerability is depending on the choices of the public prosecutors. So it's up to the public prosecutor to define vulnerable as a victim, and it depends on the kind of crime, of the type of crime. It depends on the status of the person who is involved in the investigation. It depends on the relationship between the suspect and the potential victim. So it's up to the prosecutor in charge of the case to address the victim as a vulnerable one. From this definition of vulnerability, many consequences come. For example, the legal treatment of the victim, which comprises especially the access to the help of an expert. We have to consider that in many cases, when we are dealing with vulnerable victims involved in the crimes of human trafficking, we are considering women that come from countries where gender stereotypes are strongly supported by the society they come from. So many times it's very difficult to conduct an investigation because we are dealing with women that are not able to talk to, for example, men prosecutors who want to talk only to female prosecutors. So we have to take into consideration their origins. We have to take into consideration their status when they arrive on the country. So addressing these women as vulnerable victims by a decree of the public prosecutor who's in charge of the case means allowing these women to have access to the support of special experts, especially of psychologists. It's very interesting to talk about the rights of the women in the migration phenomenon, but the dramatic fact is that we have to take into consideration that sometimes very small details can change the outcome of an investigation when we are dealing with human trafficking, because sometimes there are very huge obstacles that could be solved by a simple solution. For example, allowing the victims to be interviewed by the prosecutors at the presence of a psychologist could be very helpful, but it's not normally considered during the human trafficking investigation, because sometimes the public prosecutors don't formally define these women as vulnerable victims. So giving access to these women to the cure of the psychologist, to the help, the support of a psychologist can be very helpful to allow them to come out of the situation of violence from which they come from, because we have to consider that not only they are victims of sexual exploitation, human trafficking aimed at sexual exploitation, but sometimes they are victims of other crimes before the starting of the human trafficking itself, because we know this especially from the support that we gain from the forensic scientists. These women are often victims of rape, of sexual assault, of violence before they are victims of human trafficking. So it means that we are dealing with victims that are twice to be considered as victims. And it's very important to highlight the importance of the help that may come from the other stakeholders in this process of conducting an investigation. And as I said, the psychologists that can be appointed by the prosecutors as a legal expert for interviewing the witness, or the forensic scientist. And it's very interesting to highlight, for example, what is told in many conferences and meetings of forensic scientists, because when we ask for the support of the forensic scientists, we not only want to have an assessment of the physical conditions of the victims. When we are dealing with the forensic scientists, or medico legale, as we call it in Italy, we really want a doctor of the rights of the women. It's very important to consider that we don't want just a medical assessment of the condition of the women, but we want to have a special expert who can, by his diagnosis, to reveal us what has been the story of the woman behind the story of the crime. And so it's very important that the prosecutor doesn't tend to consider its job as a unique job that doesn't need any help. On the contrary, when we are dealing with human trafficking, we have to consider that it's a global phenomenon, and we have to address it with the help of many other figures. And for example, it's very important also to consider a global approach, which include only the help of the other judges that we have in our legal system. And we can consider it, and the Palermo Prosecution Office, we have done it many times, because we know now how the phenomenon of human trafficking works. We have been conducting many investigations, especially in the field of human trafficking by means of a criminal organization conducted by some population, especially in Nigeria, for example. This is what we see, especially in Palermo. We know that these women are bound to their prosecutors, to their offenders, by means of an oath, because they are involved by means of religious rituals that are very violent, that are very impressive, of these women who don't have a cultural background who can protect them from this form of psychological violence. So when they arrive to the country, probably they would be available to release their interview and to
witness the crimes that they have been victim of, but at the same time they are bound by the religious oath that they have made to their offenders. So sometimes it's very important to ask for counter rituals, and it can be done just by consenting it by means of the decree, for example, of the judge for minors, of the civil judge who are in charge of these women. For example, we need to allow the special cure for these women, medical cure, psychological cure, but we cannot do this as prosecutors. We need to resort to other judges in our legal system, which is the juvenile judges or the civil judges that are in charge of these women. So it's important that when we are dealing with human trafficking, especially for the special urgencies that these victims requires, that women require, we don't consider our job as prosecutors as exclusive, because we have to consider that we are approaching not only a victim of human trafficking, but a victim of a system in which dramatically women are more subjected to violence, to exploitation, and it depends not only on the features of the crimes, but it depends also on the features of the system in which these women come from, because we know that there is very high data of people mobility for many purposes, for example, for family reunification, for studies, for work, and sometimes even the mobility, especially in the Mediterranean area, is a very fruitful experiences for many women, because they get more skilled, because they have got new opportunities. Migration has been a founding element of our society, especially in the Mediterranean area, and if useful accepted, is useful lived, is an empowering experience, but not for everyone, because sometimes some people, and especially some women in particular, suffer adverse effect of this migration phenomenon, because these women are exposed to risk and insecurities during the long trip that they take to reach our country. They are exposed to violence, to sexual exploitation, they are exposed to forced marriage, they are exposed to forced labor, and of course it's important to address the social system from where these women come from, and the social system that they are going to be inserted in, because it's important to face the phenomenon. We cannot just consider the features of the crime, the structure of the crime, because we can intervene on the repression of the crime not only by means of investigation and trials, but we can intervene on the repression of the system also by means of a virtuous system when we implement the condition of the countries where these women arrive, and we can also intervene on the repression of the crime by intervening in their societies in which these women arrive. For example, it's very important that as soon as these women reach the country, they are allowed, as I said, to talk to female staff of social services, of hospital, of prosecution offices, because we know, and this is our clear experience, that these women are socially not used to talk to male staff. So sometimes accessing the same separation of gender, it's necessary in order to grant them the possibility of speaking. And we have to consider often, and this is very simple to say, but at the same time it has got very dramatic effect, that sometimes we have to face the evidence that we are talking to women who cannot simply express themselves with anyone, because we suffer dramatic lack of interpreters. So sometimes these women would like to talk, but they don't have the practical possibility of talking, because we don't have interpreters. Sometimes these women come from very far away villages with very limited dialects that are not talking rather than from small groups of people. So it's very important to grant the presence even in the prosecution offices of interpreters, because they are the only way to access the the word of these women. And at the same time, we have also to consider very practical facts. And I'm sorry, because I'm saying very simple facts, but these simple facts have a massive impact on the investigation. For example, sometimes we have to consider that these women arrive to the country for reuniting with family, and family reunification not necessarily implies human trafficking. So sometimes women arrive, they are not victims of human trafficking, but at the same time, even if they come for family reunification, they are victims at the same time, because we know that the family reunification is structured in such a way that the spouse who arrives has got the status depending on that of the family member who is already in the country. So it means that if the sponsor is a man, the woman end up depending on the man, and if the man is a violent man, the woman, even though she's not a victim of human trafficking, ends up becoming a victim of bad behavior, of domestic violence, of sexual violence, sexual assault. And we don't have tests for testing, as I said, whether these women arrive from an origin of violence. So we should grant to these women, even when they don't come from, they are not recognized as victims of human trafficking, we should grant them a first immediate access to social services and to medical services in order to assess whether they are going to be part of a unification which is bad and violent since the very beginning. But at the same time, when the sponsor is a woman, she's not preserved by violence, because we know that women have to work full-time in order to grant the access to houses, in order to grant cure, in order to grant the surviving of her family. It means that when we have women who arrive as sponsor in a family reunification, we have to take into account the fact that they are going to be subjected to social limitation, who are going to comprise to reduce their freedom. If they have to work all the day to grant the family needs, they are excluded, for example, by social programs or by language programs. So it means that they are going to get a lower qualification, and it's of course, it's a condition that it's detrimental for the women, because we know that women who arrived, especially in these migrating flows that come from Africa, are low-skilled women, and if they are obliged to take care of the family, of course, they will be their potential to increase their participation to society will be reduced. They won't have the time to follow special programs. They won't have time to access to language courses. They won't have time to access professional courses, and it means that they are destined to take care only of their family, and of course to be depending on men. And if these men are violent, they are going to be potential victim of domestic violence. So this is another very dramatic aspect that we are confronting with in our investigation with human trafficking involving gender issues, because we know and we have this experience of many successful investigation in which we have identified the potential organization, we have identified the criminal organization that are behind the phenomenon, we have prevented other the phenomenon of human trafficking. But at the same time, we know that many of these women are they become host of hosting houses, fostering houses. The problem is that sometimes there is a lack of social system who can take care of them, and if they don't have access to motivating program, if they don't have access to true working possibility, they are going to leave the fostering houses, and it means that they are going to be to enter into an unregistered system of people moving throughout the territory without any protection, without any identity, without any any benefits from the state. And of course, it creates a dimension in which from one crime to another crime, the passage is quite natural and cannot be avoided. We know that many women who are hosted in this fostering house, they live voluntarily. This house because they don't have true qualifying, true motivating, true professional opportunity to grow, and it's a very sad feeling that as a prosecutors we have the most powerful tools, that is to arrest people, to ask for verdict, but at the same time we don't have any power if we are not supported by a network of other stakeholders, as I said, forensic scientists, psychologists, fostering houses, social service, who can complete our job, because our job is to identify the victims, identify that they are vulnerable, try to test even when it's not easy. For example, and as I said in example of family reunification, the symptoms of a potential violence, but at the same time we need the support of our social nets that can help us to maintain the network of protection that we have created once the victim has arrived to our office. So what I would like to say to conclude, because my time has run out, is that of course we have very powerful system. We have the legal tools that help us to address the phenomenon with the due diligence on the protection of the rights of the victims and the urgent needs of the victim. But at the same time, law is not enough. We need humanity when we are dealing with this woman. We need to listen to their story. We need to listen where they come from, and we need to be very attentive to where they want to go to, and we have to follow them, not only tracking their way back from their countries, but also tracking their way forward to their possibly destinations. So many thanks for listening.
Thank you. Thank you very much for your contribution. We thought there was the need for combining the theoretical approach with practice, and I think we were successful. Your main points I want just to highlight. The first is the difficulty to manage the concept of vulnerability and all the dangers are entrenched in this very vague definition, and then the need to combine the aim of investigating with the protection of women that are victims of several violations of human rights. And in so doing, I think you also made a bridge with the previous contribution we had that mentioned positive obligation. And you explained to us how difficult it is to comply with this positive obligation in practice. So thank you very much. Now the debate is open. If there are questions or comments, either here or from those who are online, please let me know and I will give you the floor. Is there anybody that wants to make? So I can take you. So certainly, Professor Puma, but you have to use the microphone because otherwise nobody can listen to you.
Okay, thank you. Thank you all for your insightful considerations. I have some questions stemming from my obsession about self-contained regimes, which do not exist in international law, as we all know, or at least this is my personal feeling. The first question is two questions for Francesca. The first one is there a relationship, I mean, in terms of coordination or compatibility between these legal instruments on human rights law and international humanitarian law? I refer, for example, to migration flows deriving from armed conflict scenarios. Let's think to the Ukraine situation, Syria, and sadly, many others. So the question is, are there obligations incumbent on state parties to these conflicts regarding, for instance, the protection or even the facilitation of the move of vulnerable individuals, such as women in this case, towards a safe place? This is the first question. The second one, again, a relationship between human rights law and other branches of international law. Is there a sort of rule on open to human rights, to the human rights branch, which is Article 110 of the United Nations Convention on the Law of the Sea? I refer to the right of visit. A warship is justified in boarding a foreign vessel if, I quote, if there is a reasonable ground for suspecting that the ship is engaged in slave trade. Within this exception, in your opinion, can we put also the trafficking of women, which are sadly destined to sexual exploitment, for example? Because the interpretation of this norm, of this rule, has been in the last decades so narrow, and I would like to know your opinion.
Answer immediately.
Okay, thank you. So thank you, Professor Puma, for your question. So I start from the first one, and I agree with you that I mean, self-contained regime do not exist, and International Law Commission clearly state this, so we can start from this assumption in order to develop our consideration. Okay, I'm sorry. Does it work? Yeah. Okay, fine. So I think that I must admit, first of all, that I'm not very well, I have no strong expertise concerning international humanitarian law, so I will do my best in order to answer you. And but I think that, I mean, if a state are parties to, for instance, like international treaties which belong to this specific branch of international law, state can, of course, must comply with them. So it is absolutely necessary to strike a balance, to find a way in order to comply with international obligation deriving from human rights law and from humanitarian law. So for sure, state must to take into account obligation deriving from the two different branches.
In terms of complementarity, I guess.
Exactly, okay. Absolutely. And this can be said also with regard, I mean, the same happens if we think about international human rights law and refugee law at the same time, because I'm thinking, for instance, I have in my mind the non-refoulement principle, which originally comes from international refugee law, but we know that it has developed also in other different branches of international law. And if we think about international human rights law, the scope is much broader. So this is a perfect example of complementarity, as we know, but at the same time, the non-refoulement principle also is recognized also in international humanitarian law. So, and this represents, at least to me, the cornerstone of protection when we talk about migration flows in broad terms, without checking for which reason a migrant, men or women in this case, is not important, I mean, decide or is obliged to leave their home country. So I hope I have answered to the first question. With regard to the second one, you mentioned Article 110 of the United Nations Convention on the Law of the Sea, which recognized the possibility for a vessel to visit another boat, let's say in international waters, in case there are like elements according to which the boat is suspected of being involved in slave trade. So we can ask ourselves if this provision can be applied also in case of trafficking and smuggling, if I understand your point, your question correctly. one idea came to my mind, actually, that we can, of course, think if the notion of slavery can be applied also to phenomena of trafficking and smuggling in general terms and as a legal scholar. But in this case, I think that a big help has been provided in 2015 by the UN Security Council, because in its resolution 2240, I think for the first time, I'm not 100% sure, but quite sure, for the first time, the UN Security Council recognized the power to visit vessel suspected of being involved in smuggling. In that case, the phenomenon taken into account by the UN Security Council was smuggling. Both involved of being involved in this kind of activity off the Libyan coast. So I think that we can. To a certain extent, we can also think that the notion of slavery has some feature which are quite common also to the phenomena of smuggling and trafficking. So I think that to a certain extent this could be possible, but I think that we have an important precedent, let's say, deriving directly from the UN Security Council, which recognized the possibility of making recourse to the power set out in Article 110 of the UNCLOS Convention, especially in a specific case of smuggling of migrants. And I don't know, I remember that the power recognized in Resolution 2240 have been extended. Originally, they were conferred also for just for 1 year of time, and then this power were renewed in several occasions. I don't know if after there, I admit that the UN Security Council decided to adopt a similar resolution concerning phenomena of smuggling of migrants in other parts of the world. I confess I'm not very well updated, but for sure I can tell you that there is a concrete example of making recourse to this provision, to the power conferred by Article 110 in order to counter phenomena of smuggling of migrants, even if with regard to a specific part of the world. But this means that not only in theory, but in practice, this can be done. I hope I did my...
It would be interesting then to analyze the relationship between the UN Security Council and between the UN Security Council resolutions and the United Nations Convention on the Law of the Sea. But
yeah.
next time.
I think there is a question from online attendance, Miss Floriana. I can see the surname. Oh, it was just wrong. Okay, it's wrong. Then I want to take an advantage from chairing this panel, have a couple of questions. The first question is for our second distinguished speaker, Dr. LAWGEM. You mentioned the problems arising from the concept of vulnerability. And I want to ask you, don't you think that we jeopardize to breach the principle of nullum crimen sine lege? And don't you think that blurring of the dividing lines between trafficking, servitude, slavery, and other crimes is a way to circumvent the problem and to find a loophole in the system? My second question is for our first distinguished speaker. You mentioned the access to justice and the obligations. The European Court of Human Rights has recognized that states enjoy a wide margin of discretion. Just to remind you, the judgment MC versus Bulgaria, in which the court argued that the choice of the means to secure compliance with Article 8 in the sphere of protection against acts of individuals is in principle within the state's marginal position. My question is, don't you think that such a wide margin of discretion could, in fact, jeopardize the right to access to justice? we can give maybe the floor to Dr. Lachioma and then to Professor Mussi.
Yes, many thanks. So this is with
I'm
regard
sorry, I have to ask you once again
Okay.
to speak close to the microphone.
Okay, can you hear
Okay.
me now? Okay.
Yes, it works. Thank you.
Thanks. With regard to your first question, I need to say that when I'm reading about my cases, I'm flickering through my books and deeds. I often think that probably I'm repeating some discrimination that we used to fight. For example, considering women as vulnerable means repeating and implementing the gender issue, considering weakening the position of the woman in the society. So sometimes I'm critical to myself, but at the same time, I think that we don't have the luxury to forget is that we are dealing with women that often come from societies where discrimination exists, where stereotypes exist. Because I know, and I'm very aware of this, that these women that we are dealing with that are victims of human trafficking are very strong and powerful women. And I need to say that in many cases on human trafficking, but also in cases of sexual violence, my investigation started from the declaration, the statements of women. So I need to say that women in this sense are very strong and very powerful and very much empowered even before the start of the investigation. They were the kickoff for some investigation. But at the same time, I cannot forget, and this would be very arrogant to me to ask for something which don't belong to their countries. I cannot expect, for example, a woman, even if I know that she has got the potential to do that, I cannot expect her to speak freely to a man, even if I know that I'm dealing with women who have crossed the sea and have faced huge paths toward the desert. I know that I'm confronting with very strong women, sometimes very young women who have got women who have got also the care of families, entire families. But at the same time, a form of protecting them is accepting the weaknesses that they are forced to preserve in their own society, because we cannot forget that asking for more empowerment, asking for more freedom sometimes can put at risk the women itself. So it's important to recognize these women as vulnerable, but this is something that I have to highlight. My experiences as a prosecutor in human trafficking derives from an experience as a prosecutor in cases of domestic violence. So I was very used to handle this mechanism like vulnerability, resort to the special experts, resort to the psychologists. But normally these crimes, as you said, slavery, labor forces, human trafficking, are crimes that are dealt by by prosecutors of the anti-mafia prosecution office, because they are structured in such a way that they are connected to organized crime, and the anti-mafia prosecutors have got a completely different background. They are not used to deal with the vulnerable victims in a way that we are used as prosecutors in the field of domestic violence. So it's important to mix these two elements, which is on one side the very smart investigative techniques of the anti-mafia prosecution office to investigate these phenomena, which are very big, very interconnected, transnational, but at the same time to put into this investigation the sensitiveness that we can have as prosecutor in the domestic violence and in the gender issues department. So it's very important to mix the both of them, and I think that giving a power to the prosecutor to recognize in which cases women are vulnerable, or in general victims are vulnerable, means giving a creative power to the prosecutors, which needs to be used at its best, not having a prescription on considering always mandatory a woman as vulnerable victims means giving the prosecutor the power to consider a victim in any vulnerable in any case it is necessary. So according to me, it's the best way to grant the protection, which is to be tailored on the single cases. And I can tell you of many different cases, because we are in front of the women who arrive to Italy, for example, because they don't know that they are subjected to forced labor. Or at the same time, I'm talking about children who come from the areas of Syria, who come from very wealthy family, that they are educated, but still they are exposed to a violence that they are not used to. So these are very different situations that need to be addressed in a tailored way in every single case. The other question regarding the many different incriminations that we have in our legal system depends on the fact that unfortunately we are struggling with phenomena that are completely different during the ages. My experience is reduced because I have 8-year experience in the in trafficking, in human trafficking, but I can grant you that even in 8 years the phenomenon has changed, because we were confronting mainly with Nigerian girls coming from Nigeria for forced labor, but during the year we were confronted with huge vessels coming full of people from Tunisia. Then from Tunisia the situation changed again, because we were forced to confront ourselves with small vessels used by criminal organizations to give support to rich people who were escaping their countries because of judiciary issues. So the phenomenon has changed, and now we are confronting with another different phenomenon, where the people are arriving from the Balkans. The phenomenon is changing completely, and we have to adapt to what is needed. So and sometimes the legislation is drafted also on the results of our investigation. And for example, I had to recall a verdict that was, I need to say, very smart in the Palermo office, in the Palermo judge for preliminary investigation, because we were prosecuting a boy who was supposed to be, according to the scientific evidence that we had, of 18-year-old, but the judges decided not to prosecute him, because the evidence, which is based on scientific evidence, was actually an evidence based on theories that were built in the 50s for white men, not for black people coming from Africa. And I need to say that it was very courageous from the judge of the preliminary hearing to insert into a judgment, into a legal system, the outcome of scientific investigation. So what I need to say is that as prosecutors, as a criminal legislator, we are struggling because we cannot forget the inputs that come from the civil society, from the social phenomenon, from the historical phenomenon that we are living. That's why I say that we need to be we need to stick to humanity, not only to the law, because we have to take into consideration the people and the story that they bring to us. So this would be my answer to your questions.
Okay. Thank you for stressing humanity. Thank you very much. Professor Musi, the floor is yours.
Thank you, Chair, for your question. I think that especially in recent year, the European Court of Human Rights, as I wouldn't say abuse, of course, because it's too much, but has mistreated the notion of margin of appreciation, especially with regards to migration issues. So in some cases, this notion has been used in order to, let's say, reduce the possibility of migrants to present their application of international protection, refugees status, and so on. And the notion of margin of appreciation has been invoked by the judges of the European Court of Human Rights. I'm thinking, for instance, at the judgment delivered in 2020 in the NDNT case concerning migrants in the in the area of media in Spain, and this notion has been used in order to support a very formal approach of Spain to provide migrants with a legal way of access. There is, I fear, a concrete risk that this notion, the notion of margin of appreciation, can be used by the European Court of Human Rights in order to jeopardize the protection of migrants, especially with regard to access to justice. At the same time, and this is my hope, I truly hope that the judges of the European Court of Human Rights, when deciding the cases in front of them, will bear in mind what has represented so far one of the most relevant, let's say, principle, that is to say, at the very beginning of their activities, the judges of the European Court of Human Rights stated that the rights set out in the Convention must not be illusory or just apparent, but they must be recognized in a concrete and effective way. If I'm not wrong, it was in the article case that they recognized and they made this sentence. So I truly hope that every time the judges are, called to decide a case, will bear in mind this affirmation, which must, of course, guide their action. Thank you.
Thank you very much for both. Now time is ripe for our third distinguished speaker, Professor Thomas Griegel, who is Professor of International Law, European Union Law in Strand University. Professor Griegel, the floor is yours.
Good morning, ladies and gentlemen, and I'm afraid I have bad news for you. I will keep you from the coffee table for another couple of minutes, but it won't be too long, don't worry. In my final remarks, I sketch positive developments, ending on a positive note. Positive developments regarding women in involuntary migration flows, in other words, female refugees that constitute roughly 50% of the refugees worldwide. Gender-wise, we have come a long way in this regard, but have not yet reached the goal of fully gender-sensitive refugee law, both on the books and on the ground. Being an optimist, I suggest that we have proceeded well beyond the point of no return. In other words, the glass of gender-sensitive refugee law and practice is more than half full, but we need to fill it up further. At the outset, in the 1951 Geneva Convention and the 1967 Geneva Protocol relating to the status of refugees, sex and gender were completely absent. The specific vulnerability of females as a root cause of flight and of female refugees was simply ignored. This is made particularly clear by the definition of refugee in Article 1A, paragraph 2 of the Convention, as someone who, quote, owing to well-grounded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality, etc., unquote. That someone can be persecuted because of their sex or gender seems to have been beyond the imagination of the males who drafted that definition. But gender-based persecution is pervasive in countries like Iran, Afghanistan, and Saudi Arabia, the latter two being members of CEDAW and having been members of CEDAW for many years, and Saudi Arabia being a close ally of the Western countries. Yet the imperfection of the refugee definition compels us today to qualify gender-based persecution as persecution based on membership in a particular social group, or on another of the relevant grounds exhaustively set forth in Article 1A, paragraph 2 of the Geneva Convention, in order to grant refugee status to affected women. The most serious examples of gender-based persecution are forced marriage, female genital mutilation, honor killings, domestic violence, and human trafficking for the purpose of sexual or other forms of quasi-slavery. I would go further and suggest that degrading women to second-class citizens and enforcing a gender-based apartheid system also amount to gender-based persecution, whose victims should be recognized as refugees. But there is no international consensus in this regard yet, not least because of the sheer number of women concerned. It's easier with regard to intersectionality cases that were mentioned by Professor Mussi, like lesbian or transgender women. The Regional Treaty on Refugee Protection in Africa copies the definition of refugee from the Geneva Convention without adding persecution based on sex. The same holds true for Article 2, letter D of the European Union's Asylum Qualification Directive. But, there's light at the end of the tunnel, Article 10 of that directive, which further defines reasons for persecution, demonstrates gender sensitivity in letter D concerning persecution for membership of a particular social group. Quote, gender-related aspects, including gender identity, shall be given due consideration for the purposes of determining membership of a particular social group or identifying a characteristic of such a group, unquote. According to Article 9, letter A and F of the directive, acts of sexual violence, as well as acts of a gender-specific nature, can be regarded as acts of persecution in the sense of Article 1A, paragraph 2 of the Geneva Convention. This demonstrates that EU asylum law has greater gender sensitivity than global refugee law. Apart from the problems for women to obtain recognition as refugees for gender-related persecution, the legal status of female refugees leaves much to be desired. The terse formulation of the non-discrimination provision in Article 3 of the Geneva Convention is particularly worrisome from a gender perspective. Quote, the contracting states shall apply the provisions of this convention to refugees without discrimination as to race, religion, or country of origin, period, unquote. Discrimination as to sex is conspicuously absent, even though the UN Charter of 1945 requires, quote, universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. And the Universal Declaration of Human Rights of 1948 specifically addresses the equal rights of men and women and prohibits distinctions based on sex. A proposal to specifically include distinctions as to sex in the text of Article 3 was rejected during the drafting process of the Geneva Convention. The African Treaty on Refugees does not cover sex discrimination either. It is true, of course, that the states parties to the Geneva Refugee Convention and Protocol are now prohibited from engaging in sex discrimination also of women refugees by the global human rights treaties, complementarity, as well as their regional counterparts in Africa, the Americas, and Europe. But refugee law as such remains blind to sex discrimination. There is no specific prohibition of sex discrimination in the EU secondary legal acts on refugees and asylum either. But the non-discrimination provisions of Article 21 of the Charter of Fundamental Rights of the EU, of course, apply so that union law comprehensively ensures gender equality, also with regard to refugees. Although the Geneva Convention and Protocol as points of departure are entirely insensitive to the special needs and vulnerability of females with regard to displacement and female refugees, global refugee law has not remained gender blind. In 2002, the UN High Commissioner for Refugees issued guidelines on international protection, gender-related persecution within the context of the Convention and Protocol. The guidelines advocate a gender-sensitive interpretation of the 1951 Convention and also identify trafficking for the purposes of forced prostitution or sexual exploitation as a form of persecution. While these guidelines are only soft law, they are of particular importance because they were issued by the UNHCR that has a specific mandate regarding the development and implementation of global refugee law as a subsidiary organ of the UN General Assembly. The guidelines approach have been further refined in 2018 by the UNHCR policy on age, gender, and diversity that guides the agency's approach and addresses gender equality as being fundamental to the well-being and rights of all persons, central to the UNHCR's approach, and relevant to every aspect of the UNHCR's work. Most recently, the UNHCR policy on the prevention of risk mitigation and response to gender-based violence was issued in 2020. Enhanced gender sensitivity in the refugee context has gone far beyond the UNHCR. This is indicated by the Global Compact on Refugees that was developed by the UNHCR and affirmed by the UN General Assembly by a vote of 181 against 2, naming and shaming, Hungary and the United States, with 3 abstentions. The compact underscores the need to promote gender equality as well as end gender-based violence and trafficking in persons. The pertinent UN General Assembly resolution affirms the importance of gender mainstreaming in analyzing protection needs and the importance of according priority to addressing discrimination, gender inequality, and the problem of sexual and gender-based violence, recognizing the importance of addressing the protection needs of women. This gender-centered refugee policy mirrors the enhanced gender responsiveness of migration policy in general that was mentioned by Professor Mussi, as reflected in the Global Compact for Safe, Orderly, and Regular Migration. With regard to human trafficking, the Palermo Protocol to prevent, suppress, and punish trafficking in persons, especially women and children, establishes a link between the mostly female victims of human trafficking and the granting of asylum. Article 6 of the Palermo Protocol requires states parties to provide victims with assistance and protection. According to Article 7, quote, each state party shall consider adopting legislative or other appropriate measures that permit victims of trafficking in persons to remain in its territory temporarily or permanently in appropriate cases, unquote, while giving appropriate consideration to humanitarian and compassionate factors. The formulation is soft, very soft, staying clear of outright requiring states to recognize those victims as refugees. On the contrary, Article 8 of the Palermo Protocol considers it as normal for victims to be returned to their country of origin. But the savings clause in Article 14, paragraph 1 reserves their right under our international humanitarian law, international human rights law, and international refugee law, and in particular, the principle of non-refoulement. Moreover, Article 14, paragraph 2 requires that the treatment of victims shall be consistent with internationally recognized principles of non-discrimination. On the European regional level, Article 20, paragraph 3 and 4 of the EU's Asylum Qualification Directive kicks in here, recognizing victims of human trafficking as vulnerable persons, just like pregnant women and persons who have been subjected to rape or other serious forms of sexual violence, provided, however, that they are, quote, found to have special needs after an individual evaluation of their situation, unquote. But their victim status at least enhances their chances of being granted asylum. This mostly benefits women and girls because they constitute the large majority of trafficking victims. Article 14, paragraph 1 of the Council of Europe Convention on Action Against Trafficking in Human Persons, the so-called Warsaw Convention, goes somewhat further than Article 6 of the Palermo Protocol in requiring parties to issue a renewable residence permit to victims if necessary. Article 40, paragraph 1 of that Warsaw Convention leaves further obligations under other conventions unaffected, and Article 40, paragraph 4 reserves the rights of victims under international humanitarian law, international human rights law, and international refugee law, and in particular the principle of non-refoulement. Moreover, according to Article 17 of the Warsaw Convention, quote, each party shall, in applying measures referred to in this chapter, aim to promote gender equality and use gender mainstreaming in the development, implementation, and assessment of the measures, unquote. The reference to international human rights law in Article 40 of the Warsaw Convention directs our attention to the Convention on the Elimination of All Forms of Discrimination of Women, whose Article 6 requires states parties to take all appropriate measures to suppress all forms of traffic in women and exploitation of prostitution of women. The Committee on the Elimination of Discrimination Against Women, as the competent treaty body, issued General Recommendation number 38 in 2020 on trafficking in women and girls in the context of global migration, in which it identified sex-specific or discriminatory migration and asylum policies as one of the root causes of that kind of trafficking, because they heighten women's and girls' vulnerability to all forms of exploitation. The committee also recognized that gender-based violence is one of the major forms of persecution experienced by women and girls that may be grounds for granting refugee status and asylum and or residence permits on humanitarian grounds. This induces me to take a brief final look at the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. Chapter 7 of this so-called Istanbul Convention specifically deals with migration and asylum. Pursuant to Article 59, parties are required to issue a renewable residence permit to victims if necessary, which retraces Article 14 of the Warsaw Convention. But Article 60 of the Istanbul Convention on gender-based asylum claims introduces new gender-specific elements to regional refugee law in Europe. In paragraph 1, it requires parties, quote, to ensure that gender-based violence against women may be recognized as a form of persecution within the meaning of the Geneva Refugee Convention and Protocol, and as a form of serious harm giving rise to complementary subsidiary protection. Pursuant to Article 60, paragraph 2, parties shall ensure that a gender-sensitive interpretation is given to each of the Convention grounds, and Article 60, paragraph 3 requires parties to develop gender-sensitive reception procedures and support services for asylum seekers, as well as gender guidelines and gender-sensitive asylum procedures including refugee status determination and application for international protection. The most recent soft law rules issued by the Council of Europe consists of a 2022 recommendation of the Committee of Ministers to member states on protecting the rights of migrant, refugee, and asylum-seeking women and girls. All in all, gender sensitivity and gender mainstreaming has for a long time been extended to global and regional international refugee law. It is now for us to ensure that the gender-sensitive hard and soft law on the books is adequately implemented on the ground by gender-sensitive law school graduates. This is indeed one of the goals of the LAWGEM project. Thank you for your attention.
Thank you very much, Professor Grieg, for showing us there is some light and also for reminding important role that projects like this can play in renewing legal culture. I want to thank all of our distinguished speakers for their contributions. And I really hope this is the first step in a cultural process leading to revising law in the light of gender-based approach. Thank you very much. Now we have a 15 minutes break, and we'll start again at 11:30 with the third panel. Thank you. 11:30. You, yes. And coffee break is in the garden.
scopre, va.
Tu no, Presidente dice invece cammina.
E cammina, certo.
Ma capisci che vedi con che bagno vicino...
Dov'è il tuo cellulare?
Let's start the session dedicated to gender equality and family law. First of all, let me thank Professor Dragica Vujadinovic for the excellent coordination of the LAWGEM project and all the members of this research team, which, as mentioned yesterday, has produced important intellectual outputs, such as the textbook Gender Competent Legal Education and the Gender Perspectives series edited by Springer. Our hope is that this scientific cooperation between our universities can continue and strengthen further. First, I would like to express special thanks to all the speakers who will give their contribute to this intellectual project. And let me introduce the first speaker, Professor Camilla Crea from the University of Sannio Benevento, about gender stereotypes and rape myth, the Italian style. The floor is yours.
Thank you, Gabriele. I'm really happy to join this conference and in particular to be here again after 3 years, because I used to spend some beautiful months with Gabriele and the other colleagues here at the University of LUMSA. So thank you for giving me this great opportunity. My speech today will be, split up in 3 main parts. The first one, I'm trying to present a short introduction on what gender stereotypes are. The second part will be focused on a case law, an European case law before an Italian judgment. The third part, eventually, I will try to express some final remarks about possible way to take gender stereotype more seriously in legal reasoning in case of judicial stereotyping. Well, what we talking about when we talk about stereotypes? Social psychology literature propose many different conceptions, but now I think that we might propose a broad conception, the one made by Miranda Fricker in her milestone book, Epistemic Injustice. She said that stereotypes are widely held associations between a given social group and one or more attributes. Well, we might say that stereotypes are social and cultural construction shared in society. They are social norms that create expectation about how each person should be or behave. In this way, we might think about stereotypes as preconceptions. They present different level of generalization, so they simplify reality. But sometimes this process of simplification means also over-categorization and produces a perception of uniformity of social categories without any individual differentiation. It's quite clear that stereotypes are ubiquitous. They have a positive function. They play an important cognitive roles because they represent tools for understanding people and for rationalizing the reality. But they produce a strong negative and dangerous effect, for they create prejudice in a conscious or unconscious manner. Indeed, they may cause distorted judgment and biased behavior, such as discrimination and intergroup conflicts or violation of individual and or collective identities. We might talk about a triadic connection between stereotypes, prejudice, and discrimination or inequality. The nature of stereotypes is not completely understood, and there are many open questions. From a legal perspective, the main challenging question is that how legal rules and principles can take stereotypes seriously. From a more general and theoretical perspective, that means asking ourselves what kind of society we really want, what kind of law we really want in terms of social justice and equality. Well, gender stereotypes are a powerful example to understand what stereotypes are and moreover what they do in our society. They belong to the so-called big three in the field of inequality, I mean class, race, and gender. Beyond the sociological, post-structural, and queer theories that help to analyze such topic, it seems useful to identify some features that typify these social constructions. First, we might differentiate sex, gender role, sexual or intersexual stereotypes, or even role typing stereotypes. Furthermore, gender stereotypes, as any kind of stereotypes, have descriptive components, mainly based on statistics, or prescriptive, normative ones. For example, when we say that women are supposed to be nurturing and avoid the dominance, and men are supposed to be agentic and avoid weakness. This distinction, just to mention that, was born in the United States after the Price Waterhouse versus Hopkins case, landmark decision of the US Supreme Court on the issues of prescriptive sex discrimination. Eventually, the American literature and case law, based on the concept of intersectionality that was coined in 1989 by Kimberly Crenshaw, identified the so-called intersectional stereotypes in order to include the many indexes that cause discrimination. For example, a Muslim, very old, and Black woman. Well, in this case, we have 4 different indexes of discrimination, and the law should tackle all of them. Moreover, the most important point here is that stereotypes are individual beliefs, social shared expectation. I mean, stereotypes as social norm produce social sanction when you do not act in conformity with the conventional regime, when you do not fit with what the mainstream narrative expects. I'm quoting Duncan Kennedy in his milestone book, Sexy Dressing. This social mainstream affect also judges and their legal reasoning. And when that happens, we move from gender stereotype to judicial stereotyping that be wrongful and violate human rights. We may mention a lot of different examples, such as not criminalize marital rape, perceiving that women are the sexual property of men, failing to investigate, prosecute, and sentence sexual violence against women, and so on. In the context of rape trials, gender stereotype can be also qualified as rape myths. Just to mention some example of rape myths that act against women. If you are in a relationship with someone, there is no sexual violence. Rape is usually violent and involves a stranger. Rape happens only to certain type of women that behave in a provoking way. Rape myths are prejudicial stereotypes or false beliefs about rape, rape victims, and rapists that have a very, very dangerous effect because they shift the blame from the attackers and perpetrators to the victim. Well, it's quite clear that all this social construction derived from the so-called rape culture. The consequence is that a rape, to be real, to quote Susanne, is supposed to happen with a stranger, without consent, to very sensitive women, pretty but not provocative, women who don't use any drug, and so on. In the absence of this mainstream rape features, society tolerate rape. And this is the way Duncan Kennedy used to talk about toleratum residuum, just to explain this phenomenon. And here the thing, rape myths impact on justice and criminal system, for they undermine the claims or expectation of victims, and furthermore reinforce the ones of perpetrator, reproducing social norms. I'm not sure about, okay. The impact on judicial reasoning is huge and concealed. The assessment of the victim credibility is not free because it depends on how the victim and her behavior is consistent with dominant social values and narrative. And you know, as Robert Coover taught us, narratives have a normative value and do something in our society, sometimes more than legal and formal instrument. It's not surprising, therefore, that feminist legal theory have long emphasized the close link between patriarchal and sexist social structure on the one hand, and the high level of acceptance of rape myths on the other hand. Because, you know, the tendency to deny, minimize, or normalize male sexual aggression against women based on false myths and stereotypes stems from a clear ideology that tries to preserve or impose a hierarchical relationship between men and women. It's quite clear that rape myth disqualify the women from the rape victim status. Let's now move to the core of my speech, the Italian style before the European Court of Human Rights in searching for normative tools that might help to take gender stereotypes more seriously in the specific field of rape trials. The Italian style. You know, case law is a powerful tool for the law to reflect on itself. And this is the reason why I decided to select a couple of cases. Let's start with this very symbolic case. And the first one is an Italian judgment whose legal reasoning reveals a long-standing connection between sexist stereotypes and rape myths. The second case is the European Court of Human Rights judgment that criticized and condemned Italy because Italian judges raise guilt-inducing, moralizing, and sexist arguments that breach the applicant's private life, and because all of that expose the victim to what the European Court of Human Rights qualified as secondary victimization. The Italian case dates back to 2008, when a woman student, 20 years old at that time, claimed that at the end of a party, she had been obliged to have sexual relations in a car with 7 men while she was under the influence of alcohol. In 2013, the first instance court had sentencing 6 of them for group sexual assault. 2 years later, however, the Court of Appeal of Florence overturned the verdict, questioning the woman's credibility and assuming that there was no evidence that the defendants had committed the rape without her consent. And here's the thing. In the light of the domestic law applicable, the only thing the women could do was to submit the case to the European Court of Human Rights and complain about the manner in which the criminal proceeding had been conducted. That's what happened. The European Court of Human Rights stated that the arguments and the wording used by the Italian judges violated the right to respect for private life and the personal integrity of the women in breach of Article 8 of the Convention. Last but not least, the European Court of Human Rights questioned more generally the connection, the strong connection existing between the moralized comments used by the Italian court and the persistent in the Italian society of sexist stereotypes and gender gap. Well, I think that this Italian judgment represents a specific mode of sexualization of woman's body, with the effect of discrediting her as a true victim, moralizing her sexual behavior and integrity. In spite of years of criticism, the first way the gender and sexualized narrative undermines the women's credibility is putting a strong emphasis on her provocative clothing. Several passages in the Court of Appeal's judgment, and particularly the reference to the red underwear shown by the applicant during a rodeo performance on a mechanical bull, clearly indicates that the applicant fails to conform to the archaic stereotype of the genuine, real rape victim. Qualcuno sta muovendo. Okay, grazie. Thank you, sorry. No, I'm honored. So the underlying assumption here is that sexual abuse can be attributed to something inappropriate the victim has done. And in fact, as a matter of records, the more attractive and provocative is the victim, the more likely she is to be blamed for her assault. The power dynamic involved in the narrative implicitly tell women to dress in a less provocative way. In other words, blaming, this is the phenomenon, blaming victims is a way to exercise control over women's lives, essentially trying to perpetuate the structure of the patriarchal society. Consider, for example, the comments regarding the victim's promiscuous and casual sexual habit prior to the rape, including the fact that she had made a short porn film with one of her presumed attackers. Here again, the Italian judgment shifts the blame for sexual assault from the attackers to the victim. He described the intimate choices and private life as already too much sexualized, and eventually the court resignified the rape as consistent with consensual sex in order to deny any criminal liability. Finally, the judgment also plays upon homophobia and intersectional discrimination, because there are some comments regarding the applicant's bisexuality and non-linear life, and even her artistic interests. This is a clear way to naturalize the so-called heteronormativity, reproducing the conventional binary code in gender and sexuality. Let's move to the European Court of Human Rights judgment. Try to underscore what kind of lesson we might learn from Europe. The court, first of all, revealed a very great paradox, the societal paradox. Indeed, even though there are many domestic and international legal instruments that shield rape victims from being subject to traditional notion of rape, well, I cannot mention all of them, but many of them have been already mentioned in the previous session today and in the session of yesterday, in terms of, the European Directive on secondary victimization, the Istanbul Convention, and many other national criminal statutes that shield the victims. Well, the point is, despite all these legal resources, there is still a huge difference between passing and enforcing law, between law in action and law in books, to quote Roscoe Pound, the very father of legal realism. All these formal legal tools do not prevent to cause harms. So the court stressed a very, very intense point. Legal rules are not enough. According to the court, gender stereotypes are a cultural, societal, and institutional issue that affects judicial perception and impartiality. They arise from the society as a whole and may cause damages that must be compensated. The gender gap existing in Italian society is well demonstrated by many empirical data mentioned in the judgment of the European Court of Human Rights, and as well as many national and international reports. I don't have much time to talk about that, maybe later during the question time. The worst part is that the level of rape myth acceptance in Italy includes both women and men. Even women judges are members of society, for they have internalized social stereotypes. The member of the Italian court that we were talking about were mainly women. And it seems unbelievable, but many Italian decisions affected by judicial stereotyping in cases of domestic violence and feminicide have been raised by women judges. Let's move to the second lesson from Strasbourg. Gender stereotypes are not legal argument. They're not able to justify the domestic judicial reasoning, and they violate human rights. The point is that stereotypes, rape myths in that case, are not facts. They are just social expectation. And this is a very important point stressed by the court. Actually, it is true that the Strasbourg court is not new to harmful stereotypes in domestic legal reasoning as a violation of human rights. The court has already addressed this issue on several occasions, for example, rejecting the use of gender stereotypes of women as primary child carriers in Constantine Mark versus Russia. And, you know, this kind of stereotyping affects men, not women, since the so-called parental leave is often legally granted just to women and not to men. Another important leading case that concerned the illegal domestic reasoning based on stereotypes is the Carballo-Pinto in 2011, where the Strasbourg judges found that the compensation awarded domestically to a 50-year-old woman who could not have sexual relations after a failed surgery was reduced by the National Court partially because of the age and gender stereotypes. The Spanish court said that she was too old to have sex, so it was not important to have a great compensation for the failed surgery. That's what happened. But the case at stake, the case we are talking about today, I think that the European Court of Human Justice did something more, because the Strasbourg Court holds that rape myths can be harmful and violated Article 8, the right to a private life, but just because of the sexist arguments and language that were used by the National Court. From a private law perspective, there is not only a duty of the state to protect victims of gender-based violence, but a judicial duty to respect image, dignity, and privacy of victims. Here, the second lesson from Strasbourg. Even if the criminal proceeding and investigation process were legal, in order to prevent harmful stereotyping to be a sources of secondary victimization, we have to consider just the sexist argument and language used by the National Court. Well, this assumption is quite intense, because it admits that judicial wording do count in assessing whether stereotypes could be harmful. Judicial language is an institutional language that means responsibility for judges, and it also a performative language, as Judy Butler would say. And when we say that language is performative, that means that language does something in the world and in society, because it's a way to construct or deconstruct legal subjectivity and identity, including gender one. Thus, the judge is not only communicated to the parties their rights and liability in the context of the specific dispute. The judge is also addressing the broader legal community, other lawyers, judges, legal academics, law students, and indeed the public at large. Just a final remarks, because maybe I already 5 minutes. Okay, that's fine. Thank you. Why and how the Strasbourg Court could do more to take stereotypes seriously? Because until now, we just mentioned a couple of lessons we learned by them, but it's just a small step. We need to go forward. We have no time to deeply discuss about how the Strasbourg Court could improve their real legal reasoning and adjudication process. It could be very useful, for instance, a comparative law methodology looking at some overseas legal experience, such as the US legal system or the Canadian jurisprudence that have a long tradition of literature and case law and built up many criteria to identify, to name, and to classify illegal and invidious stereotypes. Let me just focus briefly on some possible normative tools. The case discussed today shows that the harm of stereotyping is that it justifies and reinforces discriminations. Stereotypes anchor structural inequality, and it's quite clear that only by framing invidious stereotyping as a discrimination issue, courts can transcend the level of the individual claimant and address the wider harmful implication of stereotyping. Unfortunately, the judgment at stake, as well as many other rulings made by the European Court of Human Rights, doesn't take into account the discrimination issue and evaluated the applicant rights and interests just under the right to private life, the Article 8. Even though this provision, the Article 8, helps to capture the violation of the individual identity and moral integrity of the victim, it doesn't let the discrimination issue really emerge, arguing, as the court did, that it was not necessary to examine whether there had been a breach of the principle of discrimination, Article 14 of the Convention. I think this assumption, is very, very dangerous and highly problematic for a risk to be a legal and biopolitical discourse that denies the societal and hegemonic effect of rape myths, which are harmful gender stereotypes. This kind of assumption denies the performative language, role of language in shaping individual and collective identities. The truth is that stereotype is not just an individual experience. It is a social experience that causes multiplex form of epistemic and structural injustice. Recognize only a violation of individual right to private life is a disciplinary discourse, as Michel Foucault would say, that aims to confine gender stereotypes to an individual and occasional experience to be shamed. That leaves women alone. That preserves the status quo. The social conflict of discrimination practices doesn't show up. My point is, and I'm going to finish, is that legal reasoning based on discrimination provision could be a way to take wrongful stereotypes seriously and to recognize and to promote individual and collective narratives behind the dominant ones. The principle of discrimination at least can be a potential legal means of deconstruction that can let the epistemic inequality and the social hierarchies really emerge. Thank you for your attention.
Thank you very much. It was really a fantastic analysis of gender stereotypes. Thank you. Let me now introduce Professor Cristina Campillo. Professor Campillo is full professor of international law at the University of Pavia, where she had the Department of Law. And she's talking about women legal status and private international law, the present and the foreseeable future. Cristina, Professor Campillo, the floor is yours. Thank you.
Thank you. Can I share my screen?
Yes, of course. Okay, we can see your screen.
Okay, thank you. Thank you very much. Among the 17 objectives of the 2030 Agenda, there is in the social field gender equality, Objective 5, which provides, among other things, the elimination of all harmful practices, such as marriage of girls, forced and combined, and the protection of women's rights in the reproductive field. Among the various perspectives from which these problems can be tackled, I propose here the, in truth, unusual one provided by private international law. In other words, I will try to identify the legal mechanism through which our legal system can contribute to countering the phenomenon of early marriages celebrated abroad and address the latest challenges related to women's reproductive health. Early marriage is a global and ancient phenomenon prevalent mainly in South Asia and sub-Saharan Africa. In European countries, marriages of under 18 years old are not very numerous. However, there are also marriages of under 16 years old within marginalized ethnic groups such as Roma and Sinti. It is estimated that at least 12 million girls marry before the age of 18 each year. As a result of climate change, UNICEF estimates child brides to be around 1.2 billion in 2050. The practice has been at the attention of international organizations for some time. Child or early marriage is considered forced marriage, given that the minor is presumed not to have expressed his or her full and free consent to the marriage. In the European context, the Council of Europe has taken on the problem, and the Parliamentary Assembly reiterated the invitation not to recognize forced marriages, except in the case in which recognition responds to the best interest of the person concerned or is invoked as a ground for international protection. As for the European Union, particularly significant for our purposes is the appeal made in 2018 by the European Parliament to national legislators to uniformly setting the minimum age for marriage at 18 and introduce a child-oriented case management system to determine the best interest of the child and based on it, what decision to take regarding the legal recognition of the marriage. In reality, already before 2018, some European states had passed the legislative reforms both on substantial criminal, administrative, and civil level, and on conflicts of law level, also in light of the objective of the 2030 agenda. As will be seen, however, it proved very difficult to identify a regulatory solution capable of reconciling the fundamental rights at stake, from equality to self-determination, from respect for private and family life to the best interest of the child, from the freedom of movement of EU citizens to the protection of personal status of the refugee. As for Italy, the only intervention by the legislator was the introduction with the so-called Red Code of the crime of coercion or induction to marriage. From a private international law standpoint, there is no legislative or jurisprudential intervention in Italy. After all, usually the problem of the recognition of early marriage celebrated abroad arises as a preliminary step, mainly in the case of family reunification, and is mostly cleared up hastily. Not so in other European countries, Sweden, Norway, Netherlands, Switzerland, and Germany. And it is on Germany that I would like to dwell, as German experience clearly testifies to the complexity of the problem. Until 2017, in Germany, the discipline of the celebration of marriage was found in Article 13 of the Introductory Act to the Civil Code, EGBGB, which referred to the national law of married couples, paragraph 1, without prejudice to the possibility of invoking the general clause of public order, Article 6, EG-BGB. In 2017, the law on the fight against early marriages was promulgated, which introduces in Article 13 EG-BGB a new paragraph. Paragraph 3 establishes that if the matrimonial capacity is governed by a foreign law, the marriage is, according to German law, ineffective if a spouse at the time of the wedding was infra 16 years old, voidable if he had turned 16 but was still under 18. During the reform works, the German judges found themselves faced with a case of a very young Syrian couple that also attracted the attention of public opinion. At the outbreak of the war in Syria, two young cousins, H and B, decided to flee and through the so-called Balkan route arrived at a German reception center. The Youth Assistant Office, Jugendamt, decided to take charge of H and instead direct B to a center for unaccompanied minors. The girl is in fact only 14 years old. However, H produces a document certifying the marriage, celebrating according to the Sunni rite with B, with whom he asks for reunification. The Jugendamt rejected the request, deeming the marriage to be ineffective. The district court authorizes the boy to spend the weekends with her. However, the decision is annulled by the higher regional court, according to which the Syrian marriage is likely to produce effects in Germany. The marriage would not be ineffective, but only voidable. The wedding was in fact validly based on Syrian law, a law that sets the marriage age for women at 17, but allows the judge to authorize the marriage of infra 17 years old of ascertained physical and sexual maturity. Maturity that at the time had actually been ascertained. The decision is harshly criticized in legal literature, and as was to be expected, it faces an appeal. The Federal Court, Bundesgerichtshof, confirmed the non-contrary to public order of the Syrian marriage. The court also notes that pending the judgment, the new Article 13, paragraph 3 EG-BGB has entered into force that goes alongside the general public order clause of Article 6 EG-BGB and dismantles its effects relatively to marital age. It is in fact the legislator himself who resolves the conflict with the German rules on matrimonial capacity, replacing this discretionary evaluation of the interpreter. The court therefore examines the case on the basis of the new paragraph 3 of Article 13 EG-BGB, going so far as to raise the question of constitutional legitimacy in relation to Article 1, human dignity, 2, right to the free development of personality, 3, equality, and 6, protection of marriage of the German Constitution. Thus, just over 1 year after its entry into force, the law on the fight against early marriages introduced to protect the rights of the child, arrives at the Constitutional Court for alleged violation of fundamental rights. Similar difficulties in defining the legal status accompanied the choices of women who, to fulfill their desire for motherhood, resort to reproductive medicine. As we have seen, Objective 5 on gender equality alludes to universal access to sexual and reproductive health and reproductive rights. In this regard, it should be noted that reproductive freedom has its roots in the context of family planning and then transformed in reproductive rights, in turn related to sexual rights. Given that today there is a tendency to connect sexual orientation and gender identity to sexual rights, the issues of reproduction also concern homoafective couples. In an article that appeared in March 2021 in the General Science Journal Scientific American, a really worrying fact is denounced: the 1% annual reduction in reproductive health, that is, the 1% increase in infertility problems. This progression is even faster than global warming and just as upsetting. In the 20-year period 2000-2020, the female fertility rate, that is the number of children per woman, has dropped from 2.7 to 2.4 globally. In Western countries, the rate is below 1.8, and in Italy it is 1.2, among the lowest in the world. If we consider that replacement level fertility is 2.1 children per woman, it is apparent that in industrialized countries, we are heading towards a dramatic demographic decline. In addition to the responsibility towards the new generation, there is, in short, a responsibility towards the continuity of generation. That is a responsibility for reproductive continuity. Thankfully, technological progress now offers a range of options for those unable to reproduce naturally. The bioethical profiles of assisted reproductive technology, ART, which is not the case to address here, have inevitably influenced the national legislators with regards to both the access criteria and the techniques that can be used. The most liberal countries soon turned into a sort of bioethical paradise for intended parents. In the name of reproductive freedom, today new forms of maternity are configured by conception without gestation, by gestation without conception, by conception and gestation in the interest of others, and by mere intention. As is well known, in Italy, the legislator intervened rather belatedly with a very restrictive law. The prohibition imposed were only partially gradually eliminated by the Constitutional Court. Our country still denies both singles and same-sex couples access to art and prohibits post-mortem fertilization and surrogacy, which is even criminally sanctioned. These limitations push an increasing number of Italians to go abroad, and once they have obtained what is forbidden at home, to ask for the recognition of their parenthood placing our civil status officers in the first instance and judges secondly in the face of the fait accompli. In the last 15 years, we have witnessed the multiplication of cases for the recognition of parental status obtained abroad in violation of Italian prohibition. It is not the place to fully analyze the cases. We will therefore limit ourselves to take stock of the current situation. The picture appears varied due to the non-univocal reconstruction of the limit of public order. As for the internal national environment, so to speak, this limit can be identified in addition to the constitutional norms in the norms of constitutionally bound content and or constitutionally necessary. It all depends on the inclusion of the prohibition set by Law 40/2004 in these categories of rules. Here we find two conflicting judgments of our Supreme Court. However, the limit is also characterized by an external international facet represented by principle of international derivation and by the protection of fundamental rights, first of all, by the right to respect for private and family life. The real focus, however, is the principle of the best interest of the child, codified for the first time in the New York Convention on the Rights of the Child. The fact that the interest of the child must be the subject of priority assessment does not, however, mean that the state is obliged to always recognize a status validly acquired abroad. What has been said is confirmed in the recent position taken by the Italian Constitutional Court, according to which the interest of the child cannot be considered automatically prevailing over any other counter interest at stake, but must be balanced with other fundamental rights. If this were not the case, its unlimited expansion would occur and that of the child would become a tyrant against other juridical situations that are constitutionally recognized and protected, which together constitute an expression of dignity of person. What conclusion to draw? The first conclusion is that it is not certain that the legislative path advocated by the Constitutional Court for the surrogacy be really the most suitable for addressing the issues raised by child brides and medical assisted mothers. Indeed, the legislator would hardly be able to provide a satisfactory solution through mandatory clauses that are certainly appreciable from a practical point of view, but just for this reason, potentially draconian. The traditional case-by-case approach, typical of the general public order clause, is still the most suitable for reconciling the various interests at stake through the assessment of the circumstances of the specific case, exemplary the German experience of early marriages. A more suitable approach, surely, but increasingly complex to manage. Alongside national identity values and international values, the need to also take into account European values, and specifically the rights provided by the treaties for EU citizens is increasingly evident, starting with the right to move and reside freely in the territory of member states. In the last 20 years, in fact, the Court of Justice has begun to employ the method of recognition also in order to eliminate obstacles to the movement of persons, at first restricted to the right to continuity of the name. Now the practice also concerns the right to continuity of family status. The reference is to the common case relating to the recognition in Romania of same-sex marriage celebrated in Belgium by a Romanian citizen, and to the Stolicna Pancharevo case relating to the recognition in Bulgaria of a Spanish birth certificate designating two mothers as parents, one Bulgarian and the other English. In short, EU citizens have the right to move while maintaining the status validly acquired in another member state, even if in contrast with the national legislation identity of the country of destination. Therefore, the marriage celebrated in Estonia, where the marriage age is 15, the marriage celebrated in Estonia between a 15-year-old Estonian and a 20-year-old Italian should be recognized in Italy. Similarly, for the purposes of free freedom of EU citizens, the parental status of the two mothers, of which at least one EU citizen, of the child born in Spain, and consistently of the client mother, should be recognized in Italy. The conclusion is, in short, that those who wish to have their marital and parental status recognized can follow two paths: the traditional path versus the high-speed path, to draw on a railway metaphor. The traditional way makes use of a track that is slow, however able to reach all goals. It requires verification of compliance with public order, but allows the exercise of all the rights deriving from local legislation, and therefore obtain full recognition of family status. It is a path accessible to all, regardless of citizenship. To this, the Court of Justice has added a high-speed track, which does not require any control. Not everyone can use it, as it is reserved to EU citizens, and it is limited in scope to the exercise of the freedom of movement and residence within the territory of the EU. There is a problem, excuse me. It follows that EU citizens, in addition to dual citizenship, national and European, have got a dual personal identity, the full one plus one merely functional to the exercise of rights related to EU citizenship. This situation, though, is destined to produce distorting effects at the level of private international law. In fact, new limping relationships emerge, new as the limp manifests itself, not as could traditionally happen at a transnational level, meaning that a person is considered married parent in state A, but not married parent in state B, but at the national level, in the sense that a person is considered in state A married parent for the purpose of movement and residence within the European Union, but not married parent for private purposes. In short, it is not international harmony that is compromised, but the very internal harmony of member states' legal systems. We will talk about the next developments in a future conference. Thank you.
Thank you very much, Professor Campillo. It was a wonderful presentation about the development of private international law. Thanks a lot. Now, let me introduce Professor Enrico Almureden, who is full professor of civil law at the Alma Mater Studiorum of the University of Bologna. He is talking about children's names and gender equality, the case law of the Italian Constitutional Court. Enrico, Professor Almureden, the floor is yours. Thank you.
Thank you. Thank you. And I firstly want to thank Gabriele for inviting me here in this prestigious conference, which allow me to share my opinion with old friends and new one, which I met yesterday, and also to thank very much the audience here and the online audience as well. So I start my discussion starting from the traditional family. Traditional family was the family which was ruled by the Italian Civil Code, which is 80 years old, and it was a family conceived on two principles, the indissoluble marriage and the superiority of husband. In this family, which was hierarchical, structured, and indissoluble, the discipline of the surname, which was the surname of the father and the husband, was completely consistent with that model of family, because the family was the family which was identified with the father. But over time, this discipline became not coherent. And the second thing, most important, but hidden for the first time, not functional. And I will show deeply it in the last part of the speech. Not coherent because in the 70s was introduced the divorce, and so the family was possible to solve the family just if one of the spouses unilaterally want to do it. And the second problem was that it was introduced a reform which in some ways, not completely, but it brought equality into the family. And so the family immediately became a partnership of equal, exactly as our Article 29 Constitution say, but with some limits, which we are about to see. In any case, the surname of the family began to be no longer coherent with the new model of family. And so we now can show the reason why. The reason why was, first of all, the first reason, the more evident, was that it was not coherent with the principle of equality between spouses and parents, we can say. Another problem, which was in a first moment hidden, was that this discipline of the surname was not capable to identify in a correct and complete and long-lasting way the identity of the babies, because family can also get into divorce, and so live in a dimension of the structured family, and also can be step family, so family formed after a divorce with the new husband of the mom and the new wife of the dad. And so in this new scenario, the surname of the dead was not anymore capable to identify correctly the baby into the net of the kinship and the family as a whole. And so given that, our constitutional court over time was questioned in order of the permanent legitimacy of the surname rule in Italy. Now in this slide, you can see an overview of an history which I think it length for 35 years. Because in this overview, which we can deepen in few seconds, we can have a title for every decision. For the first one, the title can be a conservative approach, but an approach based also on a biased lecture of the Article 29, which in few seconds we will deepen. The second one is there is no longer reason to maintain the discipline of the surname of the father in Italy, and so the legislator have to do something in order to update this discipline. But the turning point can be found in the European Court of Human Rights decision, which in 2014 condemned Italy because it do not contemplate a discipline capable to be coherent with the principle of equality between parents, and also for the first time to be capable to identify correctly the baby. This is the first time in which we see this second aspect of the surname of the family, which remained hidden for a long time. So after that, we have two decisions of our Constitutional Court, one in 2016, which can be entitled a first step towards equality, but a partial step towards equality. And at the end, this decision in 2022, we have achieved the equality, but on the other hand, we have discovered more complex situation which needs to be ruled by the legislator. So I go straight into this decision, but quickly. And the first one is very interesting because 35 years ago, our Constitutional Court replied, looking at the Article 29 of Constitution, the discipline of the surname is in contrast with the principle of equality, but the principle of equality can be limited if there is a good reason to do so. And the good reason was to preserve the unity of the family. In this moment, I say something which is outside my program, but yesterday in the coffee break, I was impressed, and I can say enlightened, by a brief talk with Professor Vujadinovic, which says that often the gender justice is hampered not by the law, which exists and are goods, but by the biased interpretation of the law. This is a good example because the Article 29 was there at that time, but it was read in a way which is a conservative way to read this, not, I think, not aware of the fact that the family did deeply change in the meantime. And so this approach was overruled 18 years later, in 2006, and our Constitutional Court said there is no longer need to limit the principle of equality because the principle of equality has to be completely enacted by the legislator. And so we had plenty of the new laws, prospective laws, which never came to an end. And as in many other fields happen, while the legislator is thinking about something, the European Court of Human Rights is doing something quicker. And so it condemned Italy because the legislator did not intervene, and our surname discipline continued to be in contrast with the principle of parity, equality between spouses and in general between parents. And so what did happen? After that, we did a first partial step toward parity because our Constitutional Court in 2016 said that if parents agree, starting from the basic rule, which is the surname of the father, they can agree and add the surname of the mother. This is a first significant step, but it is not enough. In fact, after this was underlined that the real equality between parents is to allow them to replace the name of the father with the name of the mother if they do agree, and to do this starting from a rule, a default rule, which is the double surname. So we start from the double surname, and we are free to decide if we want to maintain it or if you want to decide for the name of the father or only the name of the mother. So the parents are completely free to decide starting from a situation of complete parity. Is this enough? Perhaps we can say the equality is achieved on one end, but new question arises. First of all, a question which was hidden for a long time, and it is, in my view, extremely important, the personal identity of the baby. Personal identity of the baby means the capacity of the surname to identify him and to say to everybody which are the kinship networks of this baby. And so, for this reason, our prospective legislator has to select two potential models. The first one is the model which is the model of France, Germany, England. So the model I have described a few minutes ago. You are free to decide maximum autonomy of the parents, but they are free to decide also for one surname for his babies. The other one is the Spanish rule, double surname mandatory. And now I am going to finish my presentation, but in doing so, and so in indicating which is, in my view, the solution which I think is more, reasonable, I use an example which was conceived for a Spanish audience, but I think that it can work also here. The example do not use Tizio and Caio, but use two very important parents, and so the football player Piqué and the famous singer Shakira, which fortunately comes from Spain and give us the perfect example to see at a glance how the surname, double surname works in that country. So they have, in fact, two babies, and the surname of two babies is also, at the first glance, a surname which reflects the parentship in both sides and also the kinships in both sides. So you can have a precise idea of these babies, but this becomes more and more important if, as it happens, the couple do break the union, so they divorce, and there is now a new potential mother of a new potential baby, which do exist just in my fantasy and in our example. And this baby names Piqué and Kia, perhaps. And so it's extremely clear in which is the measure of the parental relation which connect him to the father and to the other unilateral brothers, for example. On the other side, my fantasy ran free, and there is Mr. Evans, which is at present a fiancé, but it can become the new husband and the father of this new baby. And so it's extremely clear how this step family is structured. And so the surname, double mandatory surname, can be identified as the rule capable to, on one end, be coherent with the equality between parents, but on the other hand, extremely functional to identify the baby in the most correct and, I say, long-lasting way, because it's possible that during the life of the baby, many things happens, and so it's extremely important to be correctly identified in this complex scenario, which was impossible to see at the time of our civil code 80 years ago. But to go ahead in this and to finish this, what happens in Italy now, and what can happen if you leave the parents free to decide for one only surname? So they are in an equal position, but they can in some ways do not see exactly the identity of the baby if they select one only surname. So Piqué and Shakira have two babies in Italy, and they have the surname of the father. Can be the surname of the mother perhaps now, but only one. And so what happens if they divorce and there is the same scenario before? This is a biased vision of the identity of the baby, because these unilateral brothers appear overrepresented in one case and underrepresented in the other. So we put a rule which is capable to put in practice the equality, but is not capable to identify correctly the baby. So the personal identity of the baby perhaps cannot be put in the hand of the decision of the parents, because I think it's a fundamental right of the baby to be represented with his kinship networks and with the identity, which reflect all the identity of both parents. So I did finish for now. I thank you very much, and also for your patience in looking this extravagant slide. Thank you very much.
Thank you very much, Professor Almureden, for your beautiful presentation. Now we have 10 minutes for questions and answers. One minute of silence. Professor Vujadinovic.
Very interesting presentations. This inspires me to think really in a new way. Thank you very much for this so clear insights about the logic, how it would be fair, would have been fair to be done everywhere, obligatory, not only the will of parents in regards of identity and rights of kids. Thank you. And what to do? What could be all instruments, of course, training of judges, workshops, and so what all instruments and modalities for used for judges to raise their awareness, what to do in order to free judicial stereotyping, to free us, to free judiciary from judicial stereotyping, and especially please try to explain why women, female judges have been so much, how to say, so much accepting stereotyped way of thinking. So we know that patriarchal heredity has been playing the role, but maybe you have some more better explanation. Thank you. So 2 questions.
Yeah. I got it. Very complicated issues, you know. Many scholars around the world try to find a solution, and mainly they image two different paths. I mean, ex ante remedies and ex post. When we talk about ex ante remedies, we talk about education, first of all. So the main point that emerged in international report as well as in national the national documents and statistics is the need for a big change in education in terms of gender equality. But the funny part is I just read a couple of days ago a report made by a commission who is in charge to monitor the Italian situation and his ability to be consistent with the Convention against the elimination of all kind of discrimination between men and women. And that's what I found out. They very, very simple way to put gender equality in education was to put the attention just on the skills between men and women. I mean, they said, okay, we have to try to explain young scholars, young people, that hard skill and social skill are not different with each other, and that even women are able to go to mathematics and physics, and even men can do other stuff in social sciences. I mean, it's not enough, but this is the way Italian parliamentary reply to the gender gap, the action to tackle gender gap. So what I want to try to say that education is very important, but what kind of education? First of all, because, for example, when I stress the attention on the internalization process between women and men, and in particular judges, I also had in mind a report on the situation of judges in Italy. They try to differentiate between different public procurement in the north, in the south, regional, or and in particular, they try to differentiate also the age of judges, because when the judges are young, they're more inclined to take gender stereotypes more seriously. But the problem is not just the judges, are the lawyers, because they have no specific competence on that, and even the psychologist community, because it's not true that every psychologist has knowledge in each field. So the point is try to create a great expertise all around the people who are involved in trials and criminal proceedings, lawyers, judges, psychologists, and of course the member of policy and so on. All people involved in that stuff should be trained. There is a need of specific expertise and formation for all of them. Because, you know, for example, I mentioned the lack in the European Court of Human Rights of knowledge about the violation of the principle of discrimination, but it's not exactly responsible for that, the European Court of Human Rights, because it depends on what the lawyers present to before the European Court of Human Rights. They mentioned just the violation of the moral integrity of the victim. They didn't mention the multilateral and collective dimension of discrimination. That's the main point. So, ex ante remedy, ex post, of course, it depends on ex ante remedy. More educated are all people involved in criminal proceeding and more generally in judicial decision-making process, more we can reduce the risk to impact on gender. And also because sometimes when we talk about gender stereotype, there is another stereotype strongly connected with that one, that we want to just have a social justice word only for women, but it's not true. First of all, because stereotypes affects men as well as women. I mentioned the case about parental leave, but there is a strong and big literature on the so-called toxic masculinity. If a man wants to do some job at house, it's not able to do that because also society put the attention on that, saying, "Oh, you're not a macho." You know what I mean? So I strongly believe that it's important to have this kind of education and training, and expose the discrimination level is important to make visible the societal effect and the cultural effect. But it's not the only thing we can do. I think the third way to be considered is the role of torts and liability in civil liability, not only criminal liability. I'm doing some research about that, and I'm just started to do that. But I strongly believe that another way could be avoid criminal liability and try to put the attention just on civil liability in terms of punitive damages for the perpetrators and attackers in case of sexual violence and feminicide and so on. But it's a very long history, and maybe we don't have enough time to discuss about it. I hope to have replied to all these questions.
Thank you very much. We have another question. Thank you.
Thank you. I just wanted to make a comment on the child marriage issues from a Swedish perspective. Because under Swedish law, it is completely, I mean, a child marriage can never be recognized if one party is still under 18 years old. That's not possible. And if both parties are over 18 years old, it can only be recognized if there are extraordinary reasons. So it doesn't. It's not even enough with like special reasons, but it really has to be extraordinary reasons. So it's very difficult to have a child marriage recognized in Sweden, and it is also, as in many other countries, a criminal offense to enter into marriage with a person who is under 18. And we actually see that issue quite a lot with migrants coming to Sweden when they have married, and it was completely legal under their law. But and normally we have this principle of that an action needs to be criminalized in both jurisdictions in order to be a criminal offense in Sweden. But we have an exception for child marriage, so it can be completely legal in the other country, and then the two spouses come to Sweden, and then they have suddenly committed, or the man usually has then committed a criminal offense, and then he will get issues with his residence permit due to the fact that he married, or they married completely legal in the other country. So the rules are extremely strict in Sweden there. And I could also just comment just very, very briefly on the name laws in Sweden. There we actually quite recently got the situation that we don't have boys' names and girls' names. So the first name, it's gender neutral, so you can actually name a child to a girl to what was traditionally seen as a boy's name. I just want to share that.
Thank you very much for this point of view. We can collect other questions. Professor Evola, before.
I have a question for Professor Muellen and a few comments on Professor Crea's speech. My question is whether or not the Italian Constitutional Court make use of international conventions, and if they refer or not to the best interests of the child, or if you rely on the European Convention on Human Rights in arguing that the interest has to be protected is the identity of the child. As regards Article 14 and the use, it's quite interesting, but I'm afraid that it will not work in a few years, because the principle on non-discrimination does not stand alone. There is always the need to associate it with a breach of the convention. And the European Court of Human Rights tends to avoid to use it once found there was already a breach. As regards the way in which courts work when there are female judges, the interesting point that there was a strong pressure to reshape the composition of courts and to enable women to exercise jurisdiction. And the idea was that they could contribute to gender equality, which was not in fact a real solution, because first they could have to apply a gender law, and it's quite difficult to assess a gender law in a gender perspective, comply with the principle of legality. The second point is women can be conservative, happen, and not feminist. And therefore, maybe the need is to have not female judges, but rather feminist judges. And that's the reason why there is a trend to revise already given judgments. And that's what we did, feminist judgments, moving from the so-called women question. So moving from the women question in deciding cases could take the women point of view and women's rights into consideration, and then tend to establish a better gender balance decision.
Okay.
This is question more.
Thank you. Good morning. My question is for the first panelist, and if you may, I'd like to draw an analogy with the previous panel. We talked about human trafficking, and the first speaker in that panel mentioned how sometimes certain terminology can actually exacerbate the stigma that attaches to victims of trafficking. And given this use of terminology, isn't part of the problem not just maybe that judges need to be more trained not to be so gender biased? Isn't part of the problem is that our legislation is still gender biased, and that what we need to do is actually go through an exercise where we make legislation gender neutral, and particularly at the international level, which still uses the he as the way to draft provisions applicable to what we're talking about. So isn't that part of the problem? Legislation.
Thank you. Any other question?
Good morning, everyone. I have a question for Professor Almoreden, which is, I can say, a sort of consideration, because I found your solution that you proposed very shareable and also very respectful of the genetic identity of the baby. But I think that it could work as long as we foresee some corrective measures. For example, in the case in which the father doesn't want to recognize his son, or for example, in the case in which the father is unknown. So I think that in all these cases, it could be a negative mark, the fact that the baby has only one surname, I think, because it could be seen by society as a only genetical son, I can say. So I think that it works, as long as we predict, as long as we foresee some corrective measures. Thank you.
Thank you. Any other question? So please, first Professor Crea and then Professor Almoreden.
I'm not sure, to be honest, I really got your question. I understood that the principle of discrimination doesn't work alone. I know there are a lot of procedural barriers in order to apply it. I know that. But the reason I put the attention on this principle is based mainly on a comparison between the Canadian experience, the constitutional jurisprudence in Canada, as well as in relation to the many case law that comes from the United States experience, because they started to fight against stereotypes many years ago. So we started just now, and as a matter of fact, the president of the European Court of Human Rights, Robert Spano, very recently said that the main important challenge to be take care of is exactly the relevance of the stereotypes, because the first point is that there is no a correct method to identify. They don't identify stereotype. They don't name stereotype, because not all stereotypes can be harmful, just some. I mean, if they are just a descriptive components based on statistics, they're not absolutely harmful or neither illegal. So the second reason where in base of which I decided to put the attention on the principle of discrimination is because if you say that just the problem is the violation of the individual integrity, that means not to consider the societal effect, the multilateral and collective dimension of the damage. In terms of diversity, because you mentioned the problem of diversity and the expertise in terms of feminist perspective as well, family perspective, if I got well your question. I totally agree, but you know, even in that topic, there is the problem of the meaning of diversity, because sometimes we think that just if we guarantee the presence of women inside the court, we can help to take this kind of conundrum very seriously, and it's not enough, because it depends on what kind of role and importance they have inside the court and what kind of education they got it. So there are a lot of multiple factors to be considered in order to do something. I don't know exactly if I correctly answer to your question. Maybe we have time to talk about later about it. But there is another thing I wanted to stress, because I don't know the name of the professor at the end of the room. Yes, about the role of legislation. It is true. Law is made by man, and he taught by man, he managed by man. So, but the point is, as I tried to demonstrate in my speech, that the problem is not law, because there are many legal instruments we already that already consider the gender gap. There are many instruments. The point is how to apply, who has to apply, and how to do that in a gender balanced way. So it is true that legislation can help, but this is not the problem, because the main problem is the law in action and law in the book. That's what I strongly believe. Thank you.
Thank you. Please, Enrico.
Thank you. I try to reply to both questions because in some ways I see them connected, because I think we have to assess the best interest of the child in two perspectives. One is general, which is in general the best interest of the child, looking at the surname, and one is a case-by-case perspective. And so I go to the general perspective first. The general perspective, I think I continue to say, is to have a double surname for this reason, that we can find also in supranational convention. The reason I think is to be perceived and represented in the most exhaustive way. And so also the principle that you have always the right to maintain the relation with your parents, both parents and both the branches of family kinship, can be represented in a double surname, because they continue to be connected with all the family, and mostly is extremely clear the identity, the history of the family, etc. But I go to the second question. The second question is what happens if in specific case there is a specific interest to do not have a double surname? This can happen. For example, in case one of the parents is particularly negative. And so for these cases, we need, and we stress this, we need also an external control on the interest of the child, which in fact is extremely strong in our present reform through the introduction of the special person which represent the minor in many affairs, even in this where parents are in contracts about the selection of the surname, for example, or the idea to which somebody looks outside the family, from outside, and looks at the interest of the child going over the assessment of the parents. I want to add just one thing. Another risk is the multiplication of the surname over time. This is not a significant risk because the Spanish experience shows us that every generation decides for the surname. And in this perspective, there is something which is richer, because if you think when you are a baby in Spain, you born with two surnames, which tell the story of both branches. And then when you become parent, in the next generation, you are free to look back and decide what is the most relevant part of you which deserves to go ahead, and which is the part which is important, but is important for you, not so important for your baby. This is necessary because you do not have plenty of surname, and so in this case you are called to exercise a self-autonomy, which in our system is now precluded because you born with the surname which the system select for you, or in the future which your parents arbitrarily selected for you, depriving you of this freedom for the future. So this is another reason why I think that the Spanish model is to look with an extreme interest. Thank you.
Thank you, Enrico. I would like to express special thanks to all the speakers who demonstrated with their excellent presentations that despite the efforts made to prevent gender discrimination in the field of family law, we may still encounter several examples of gender inequality. Sometimes we still find disciplines, regulation that lead to direct discrimination on the basis of gender, but more often the sign of discrimination may be seen in the application of legal rules or in their lack of application. So the core of problem seems to be in the mentality of jurists, in their tradition, in the persistence of customs, which can also be expressed in the form of cryptotypes. Our speakers show that the study of gender perspective in family law cannot start if not from the evolution of the concept of family, from a traditionally grounded model male-dominated by husband or father to a gender equality-based model. In the Western legal tradition, the marriage regulation reflected a division of roles strongly unequal. The husband was the head of the family. He had the power of control over his wife and the children. He was the only holder of parental authority. But in our age, marriage underwent a process of evolution in all European countries to one model founded on the equality of reciprocal rights and duties between the spouses. However, as Enrico Almureden's beautiful presentation showed, some disparities in the treatment of wife have only recently disappeared. such as the automatic and necessary attribution of paternal surname, even if the attribution of paternal surname to children is a manifestation of the male's hegemonic role in the domestic sphere, typical of a patriarchal model. In some national legislation, like the Italian one, this preference continued, despite its opposition to an egalitarian family model, which implies recognizing the same rights for both parents in relation to their children without any discrimination in relation to the right to respect for family life. More egalitarian family laws have been developed to account for plurality and diversity of the ways through which family relations are shaped in contemporary societies. During the last decades, the traditional family has been replaced by a multitude of understandings of what constitutes a family community. Family is not only formed by a heterosexual married couple whose members have assigned specific gendered roles. In European legal systems, several fundamental principles that design the family no longer as an institution carrying interests which are superior to those of its members, but as a group where to develop the personality of its members. Only a regulation inspired by the equal position of partners is fit to achieve the material and spiritual communion of life, which, according to the European Court of Human Rights, is the essence of family. So the European framework, the framework of values, confirms a pluralistic vision of the family as a community based on affection, which is awarded legal protection as a place where the individuals can exercise their fundamental rights in an equal position. In particular, Article 8 and 12 of the European Convention for the Protection of Human Rights and Article 7 and 9 of the Charter of Fundamental Rights of the European Union acknowledge as prerogatives of the single individual the right to respect for family life and the right to marry and to found a family, rejecting any institutional conception of the family as an organism placed between the person and the state, with group interests prevailing over those of individuals. The pluralism of family models requires a reconsideration of the principle of the unit of the family, which does not justify any authoritarian and hierarchical organization of family relationship. The principle of the unit of family must be understood as a need for mutual solidarity and cooperation, aimed at guaranteeing the attitude of the family to promote the development of the personality of its members. There is no conflict between the principle of the unit of the family and the equality of its members, because the family unit expresses that balance between freedom and responsibility, which characterize a modern conception of the group. And in this perspective, Camilla Crea's beautiful report proved that gender stereotypes are social norms, a social mainstream that affects judges and their legal reasoning, and showed that violence cannot be considered as a question pertaining to the private sphere, but it has to be identified as an issue of both international and domestic legal concern. In that respect, for example, the European Court of Human Rights underlined the duty to take positive action to prevent a risk to a victim of violence recognize the question of violence as a problem affecting women and children's fundamental human rights. The decline of marriage as the only foundation of family capable of confining every different affective choice to the sphere of facts has opened up a new horizon, characterized by different alternative family models. European legal systems have gradually removed all the obstacles that could lead couples to consider marriage as the only real alternative and has started acknowledging cohabitation as a community where people can express their personality and around which revolve interests worthy of protection. European legislations and courts have led the way to a process of privatization and fragmentation of the so-called family archipelago, now made up of new open social formation and where a protected family life may be carried out. Nevertheless, according to the Strasbourg Court, although it can no longer be argued that the right to marry, enshrined in the Article 12 of the European Convention, should be limited in all circumstances to opposite-sex marriage, member states are under no obligation to open the institution of marriage to same-sex couples, which is not a conventionally obligatory option because of the connection to sensitive moral or ethical issues. National authorities are, however, obliged to take measures designed to ensure effective respect for family life in the sphere of interpersonal relationships, including general recognition for couples who are in a stable relationship and cannot access marriage. European law, nevertheless, has offered a decisive impetus to the progressive harmonization of the discipline of family relations under the sign of a pluralistic approach. On the one hand, different European regulations have adopted rules of private international natures which aim to standardize significant sectors of family law. On the other hand, in the European legal space, it's possible to witness the circulation of legal models open to the recognition of couples and offspring relationships that transcend heterosexual marriage. They have entered domestic law through the case law forming as a result of a conformity check with public policy. By way of example, although the marital status falls within the exclusive competence of the member states, the European Court of Justice has recently held that in order to grant the right to family reunification, the term partner has to be extended to homosexuals who have European citizenship and have moved to another member state, notwithstanding the fact the legislation of the latter state recognizes marriage between people of the same sex. The need to grant the effectiveness of the right to family reunification reveals an expansive force, prefiguring a neutrality for European law of the concept of partner, able to include any person bound in marriage with a European citizen regardless of the gender. And an equivalent process of plural declination can be registered in the field of procreation. First of all, a plural image of family is provided by the tendency to grant filiation and protection, which is independent from the features of the relation existing between partners, and reach the recognition of juridical relevance to all child's family relationship. The gradual removal through the activity of the courts of unequal treatment based on the existence or inexistence of a marriage bond between the partners is often achieved by the use of the best interest of the child principle. Jurisprudence leads all the filiation relationships back to the scope of the rights to respect of family life, which does not allow any discrimination grounded on birth. It exists then a familiar life of the child which is established ipso iure at the moment as an effect of the birth, so that is independent from the couple status, being the presence of parental cohabitation equally irrelevant. A full grant to natural children of the right to develop normal familial relations requires national authorities to place them in the similar status to the one of legitimate children, forbidding any kind of patrimonial or succession right deprivation. On the other hand, biological descent has lost its role of exclusive paradigm in the filiations regulation, at first through the institute of underage adoption and subsequently with the regulation of the assisted reproduction techniques, which give priority to the responsibilities assumption aspect over the genetic derivation one. Moreover, parenting is not defined on the basis of biology. The development of assisted reproductive techniques have favored the emergence of new family models, insofar as they make it possible for single persons without a partner and same-sex couples to become mothers or fathers. However, the Strasbourg Court, together with several other constitutional courts, has clarified that the possibility to split procreation from natural conception, favored by scientific and technological progress, does not entail a right to parenthood. So it's possible to justify the provision of specific condition of access to the reproductive practices, which sets some limits to the desire to have a child through the use of such technologies, functional to the protection of human dignity as well as the rights of the conceived and of the future born and of the pregnant mother. In this perspective, it's possible to consider as fully legitimate those legislative solutions which, within the discipline of the assisted procreation, on the one hand, assign to these techniques a name which is lato sensu therapeutic, and on the other hand, require to respect a familiar model marked by the coexistence of a paternal and a maternal figure. In particular, according to the jurisprudence of the Supreme Courts, excluding homosexual couples from accessing artificial insemination does not amount to unequal treatment in the light of the fact they cannot be compared to infertile heterosexual couples. Thus, we cannot consider as fully reasonable the belief of the legislator as interpreter of national community, according to which a family ad instar nature, to parents of different sex, both living and in potential fertile age, depicts as a general rule the most appropriate place to welcome and raise the newborn. There are words of the Italian Constitutional Court. The presentation of Cristina Campillo showed us the decisive unifying influence exercised by private international law, the relevance of which increased because of the enhanced people's mobility beyond national boundaries that no more involves just a minority fringe of the population. a reinterpretation of the concept of family from a gender equality perspective affects private international law on various aspects. Emerging principle as the international continuity of the status represent a limit to the disavowal of foreign judgments and acts because the maintenance of bonds already established is connected to the right to respect of family life, even if it reflects family models different from those of national laws. In the second place, a pluralistic tendency emerges from the increasing space reserved to private autonomy in the choice of the competent jurisdiction as well as of law applicable to family relations. Within the limits of public order, the choice of the applicable law fulfills the parties' interest to subject their relation to the rules they consider more adequate to their needs, also of cultural nature, confirming the approach of returning family relations to a pluralistic civil society, together with the identification of personal rights spaces within the legal system. In conclusion, family law has an interconnection between private and public spheres is the mere site for the promotion of gender equality in full respect of fundamental values and principles of European legal systems. The analysis of these issues by our speakers has clarified why it's important to reconsider private law for a gender equality perspective for the construction of an egalitarian family model, and how the introduction of gender competent private law can contribute to a full affirmation of equal rights and responsibilities, not only at the formal level of legislative recognition, but also at the substantive level of interpretation and application of law. Thank you very much. Thank you, and now it's time for lunch.